Stadium, Mdantsane, on the 28th of July 2018. The incident led to the arrest of the accused and his subsequent appearance in court on 27 November 2019. Thereafter, as a result of the COVID pandemic which the country faced, the accused appeared for the first time in person before this court, and you'll need to bear with me here, on the 29th of March 2021, on which date a trial date was then secured. The trial date for 4 days to proceed was 27 August 2021. However, the erstwhile state advocate was ill and she had notified parties beforehand that the matter may not proceed, and a postponement for trial was arranged in the absence of the accused and the defense team, and the trial date then secured being 28 February 2022. On the said date, Advocate Sisa appeared on behalf of the state, and the case formally proceeded, or the trial proceeded, on 1 March.
This one's better.
1 September 2023 was the following dates up to 14 September 2023. That was 4 days, and the state case was closed on the 14th of September, meaning it was a total of 13 court days that was spent on the state's case after hearing plus minus 19 state witnesses and 3 applications brought by the defense in that period. I would say 2 because the 174 I'll deal with now. As from the 14th of September, the matter was postponed to the 20th of September 2023, whereby a Section 174 application was brought by the defense, and the ruling by court on the 19th of October 2023 was then ruled in terms of Section 174, and that ended the state matter, the 3 applications, and it lasted a total of 15 court days. During the week of 18 June 2024 to 20 June 2024, after 3 consecutive days, the defense case was closed, and on 1 November 2024, the date was secured, including the date of 9 December 2024, was set aside for address on merits. However, due to myself having sustained an injury, I indicated to the state and the defense that there's a possibility that I may not be present on the 1st of November, which I happen to be, and they had elected, correctly so, the safest option was to proceed on the 9th of December 2024 for address on merits. Indeed, then it had proceeded on the 9th of December 2024, continued, where am I now?
Kom aan, Tannie Judge. Kom aan, Tannie Judge. Skrik wakker.
4. Thereafter, 29, yes, the defense case was then closed. It continued 29 September 2025, 30 September 2025, and 1 October 2025, for the extremely long judgment delivered by this court. I still shudder. Thereafter, it was postponed to 23 January 2026 for the pre-sentence report, which was then, the court heard the evidence of Ms. Jessie Thompson, and from that date postponed to yesterday, 15 April, and I will summarize the proceedings that took place yesterday, and then hence we find ourselves here today, 16 April 2026. In total, I think what felt like an extremely long time, and which has been discussed as 7.5 years, it's clear, having to combine 6, 7 defense counsel, state, court was available, nonetheless was quite a task, and it amounted to the matter proceeding plus minus twice a year on 4.5 days per session. So the trial lasted, I would say, plus minus 31 days. Okay. Let's just see where I stopped. The court has decided to, in this instance, instead of starting by placing on record the provisions or principles traditionally taken into account by any sentencing court, to deal with the mitigating heads of argument placed on record by the defense, thereafter with the address by the state, and then the court will proceed in calmness with the principles applicable before sentence.
Yo, detailed.
Okay.
I like it.
First then, with regards to the heads of the defense, and the same will apply to the state, the court does not deem it necessary to repeat what has been placed before court. The defense had submitted detailed written heads of argument in advance and then addressed the court yesterday, being the 15th of April 2026. Therefore, the court has indeed had sufficient time prior to yesterday to read, peruse, and after yesterday's arguments to digest what has been presented to court by the defense. I will start off by, it goes without saying that in this instance, the defense had requested that or stated that there is no other sentence which is appropriate save for a non-custodial sentence, and I will continue with that at a later stage. Therefore, the court has had the opportunity to visit and peruse all the case law as quoted in great detail by the defense and has given it the full attention that it deserves.
But
the case law is attached, although in 3 pages, to the heads of argument filed by the defense. It will be a moot exercise to repeat all the cases listed, unless you would require me to do so.
deep heat.
The same may be said regarding the pre-sentence report. It was submitted to court on the 23rd of January 2026, and Ms. Thompson had read the report into the record verbatim. Therefore, there is no need to repeat the contents, as it is reflected and recorded and forms part of the written transcription and record of this court. The court therefore has had more than sufficient time to peruse and to take note of the contents of the said report, and combined with the evidence in chief, the cross-examination that followed, including the re-examination and clarity questions by court, it is clear that the said pre-sentence report has been noted fully, and I will deal with the recommendations shortly.
Smash that like button,
The
everybody.
contents are noted and accepted, therefore,
If
as
you want him to
evidence
go to
on
jail,
behalf of
Got a great business idea? Give it a domain name from GoDaddy. Every order comes with our effortless AI experience.
indeed scrutinized the case law quoted by the defense in paragraphs 25, 26, and 27, and the court reiterates the importance of the findings made regarding the role of the courts in upholding the Constitution, wherein the state is described as the role model for our society. This court is in total agreement with the submissions that let me just open this file.
Ja, Tannie. Moenie kak vat van daai file nie, Tannie. Anders gaan daai file ook 'n tronkstraf kry vandag. Pas op, file. Daai file gaan gepedo-file word. Oh, this file is a pedophile. Sorry, I'm just excited, okay? I'm just excited.
No, I can see that.
Thank
This
you,
court
Tannie.
is therefore in total agreement with the submissions by the defense that a court's impartiality must never be open to reasonable doubt. For its moral authority, without it would cease to enjoy legitimate public confidence and ready compliance with its decisions by all, and that our courts are to defend and uphold the Constitution and the rights entrenched therein.
Yes.
More so when the deprivation of an individual's liberty or freedom may be affected. It is indeed a core right to be enjoyed by all. Paragraphs 28, 29, 30, 31, and 32 sets out all the examples of sentences imposed by our courts as stipulated in the heads of arguments. There is no need to repeat the paragraphs, it was read into the record. What is clear is that there are a variety of sentences imposed by our courts regarding the possession of firearms over the years, pertaining to semi-automatic rifles, pistols, revolvers, including offences that were committed using firearms. What is to be distinguished in these matters are notably, as raised by the defence and as per the pre-sentence report and viva voce evidence of Ms. Thompson, the circumstances under which the offences were committed, including the purpose, therefore, the issue whether any harm or injuries emanated from the offences. Further, that the ammunition was fired had been described as celebratory shots, and that there is no case law pertaining to the facts relating to the matter before court, more so based on the term used being, and I quote, celebratory shots. A further submission by the defence on record mentions that should any court consider a custodial sentence as appropriate in the matter before the court, it will be seen as the accused is singled out for unduly harsh punishment.
Nonsense.
The defence concedes the offences are serious.
Tracy, thank you for that insane super chat, by the way. Thank you, thank you, thank you. Absolutely insane. Thank you.
Truly, again, emphasize that the duration, circumstances, including the lack of harm to person or property, should be considered. That indeed it is the accused's right not to show any remorse. It has no impact on sentence. Further, that the accused regrets the perception that his actions created. When dealing with the pre-sentence report, it may appear as if it is a repetition on the side of the court, but I need to mention, because the points raised by Ms. Thompson indeed overlaps with the heads of the defence drafted on behalf of the accused. In addition to the heads, I will add the following: that the accused person's personality type was assessed, and the reason for doing so was to offer context to his conduct and potential behavior expectations. Ms. Thompson had regard to the personal circumstances of the accused, his background, education and career. Further, that the accused continues to assert his innocence. Nevertheless, however, he regrets the incident. The report deals with the evaluation of actual and potential harm because of the offences, the seriousness of the offences, as well as, once again, the purpose of the offences. And in recommendations, Ms. Thompson proposed that a monetary fine as a sentence option should be applicable, and describes a fine as a sentence option which will reflect the gravity of the offence.
Ah, bullshit.
Further suggestions by Ms. Thompson were to restrict the accused person from obtaining a firearm license for a specified period.
He's
and
got
that
security,
he
he
should
doesn't
be
need
ordered
it.
to make a financial contribution to Gun Free South Africa, an NGO focusing on reducing gun violence in South Africa.
Gun Free South Africa.
She also testified,
Idiots.
and it is contained in the said report, that the firing of the celebratory shots had been deliberately planned as a distinctive element of the event, reflecting the established tradition of incorporating unique features into each celebration. She continues to state that the planning does not suggest that the activity was undertaken with the intent to commit an offence or endanger lives or cause damage to property.
How's it, Mark Rock? Aren't you streaming?
And as mentioned in paragraph 17.3 of the defence aids of argument now, that the careless and reckless discharge of firearms in a public setting conveys an inappropriate message about gun safety and responsible firearm use. Now, in this instance, it was mentioned that particularly when a prominent leader exhibits such conduct. The court agrees with this submission. Further, the court agrees with the submission by the defense that the actions of individuals in positions of influence are likely to be emulated by their supporters, thereby warranting what is perceived to be more severe assessment of their behavior.
Yes.
However, the defense then proceeded to state that the behavior of the accused indeed once again reiterated did not cause harm to person, property, and the court was then requested to consider that the said firearm in question was returned to the lawful custodian promptly, and that the celebratory shots were fired in a very short space of time, and that the accused had not loaded the ammunition personally.
Okay, so what does that matter?
Further, that the accused had obtained the firearm from an individual most likely affiliated with tactical security services. On this aspect, and on certain aspects raised by counsel yesterday, it's clear this aspect was dealt with in judgment. It refers to the merits, and when we deal with leave to appeal the application, it is when the court will hear the merits. The court's finding in judgment is clearly stipulated regarding how possession, there was no finding as to how possession was gained. That is as far as I'm going to say. The rest we'll do during leave to appeal.
Liquid Rhino Gaming, thanks for the 50 New Zealand dollars. It's appreciated. I'll deal with all of the super chats after the stream. Smash the like button, subscribe, and let's listen to what the judge has to say.
Reply by replying counsel.
I believe he's going to get 3 to 5 years.
That in essence were the points raised by the defense and the social worker, Thompson. And as I've stated yesterday, reading the paper gives new meaning when one hears the oral arguments in court. It gives more perspective, insight, to see and hear the tone of how a statement is made as a different impact on a court as a piece of paper which is words. So therefore it was important for the court yesterday to pause when it did and then retire to indeed consider sentence.
Yes.
Those were the aspects as stated, dealt with by the defense, and I will now deal with the aggravating circumstances as indicated or raised by Advocate Sisa on behalf of the state.
Here we go.
The state submitted that they request that the court should consider a custodial sentence in this matter for the following reasons. That the incident was planned and it was deliberate and executed with precision, and that the submission is made based on the accused's own evidence. Also on this aspect, I would say we will deal with the merits once we reach that point. Further, that it was a collective decision made by the EFF's leadership and that it was planned to entertain the crowd to ensure that the crowd is not bored during the event.
Yeah, if they're bored, let's just shoot some guns.
Relies on the submissions based on the evidence of the accused that, I quote, everything was perfect and calculated and designed to be the way it was done, unquote.
Nonsense.
Therefore, it was not an act based on a lapse of judgment. These submissions was then substantiated based on the case law by the defense and similarly quoted then by the state. The state and the defense basically, in fact, relied on the same case law pertaining to this matter. The state continued to submit that on the ballistic evidence presented, it was established that to discharge a semi-automatic rifle in a built-up area densely populated using a .223 Remington round was fired and that retains lethal kinetic energy on descent. The potential for mass injury or harm was real, it was foreseeable and scientifically established. Mdantsane is a residential area.
Yes.
The state alluded to the fact that the accused position as a public leader and role model is, I would say,
Hy het 'n hurp op sy lip.
submissions made thereafter by the state requested the court to consider that the accused is a member of parliament and also the president of a political party,
Yes.
admired and followed by millions of South African citizens,
Well, not millions
and
anymore.
arguing that it is aggravating and not mitigating as per the defense submissions in this regard. The state referred to the video footage which was accepted by court. That again, I will say, deals with the merits. It was clear what footage was admitted by court and what was not admitted.
Ja, wat kyk jy? Kyk na die judge. Moenie na my kykie. Focus on your future.
The state
Don't look at me.
alleged that
Kijk
the
naar die
accused
judge.
clearly lacked insight and accountability
Hey,
and sought political
Hey.
justification as an
I say.
excuse,
As
thereby undermining the public confidence in the administration of justice. These submissions was followed by the concerns the state raised regarding the evidence and pre-sentence report drafted by Ms. Thompson and the findings by the witness and the submissions by the defense regarding the brevity of the possession and that it was not accidental, and that the discharge of a semi-automatic rifle cannot be described as benign, and since the risk of injury or harm is extreme. Celebratory purposes in this regard, the state submitted that this type may not be condoned, this type of discharge may not be condoned, and that the law makes no provision for such actions. The state then embarked on the discussion and submissions regarding the case law, which was placed on record. I am not going to repeat, it has been noted. The only difference I may add by the side is that although the state and the defense relied on the same case law, it is clear that the state will use the portions which is beneficial to them, and the defense will obviously use the portions which is beneficial to the defense. And ultimately, at the end, the court is required to bring them together. The fact that the state further continued that the fact that there appears to be no harm or injury caused as a result of the commission of the offense is conceded by the state, however disagrees with the defense regarding the weight that it should be attached by court. The parliament criminalized the creation of risk, not that there is a requirement of an actual harm or injury, but the actual act itself. The state continued to highlight three, which they termed, I'll say, pointers, that being the imperative of equality before the law. I'm not going to elaborate on that point at this stage. The imperative of proportionality and the imperative of deterrence. Those were the three highlighted by the state. And concluded its submissions by referring to State versus Zinn and pressing
Yeah. Tannie Judge.
I'm trying to also expedite the
I hereby sentence you to life imprisonment with no option of parole.
The state then submitted that the proposed sentences will give proper effect to all the principles and objectives set out in State versus Zinn with safety, and it will satisfy the constitutional mandate of equal treatment before the law, and it will serve the legitimate and pressing interests of a society that has the right to expect its leaders to obey the same laws they are elected to uphold. Now, the court will proceed with the principles traditionally taken into account by sentencing court.
Gooi rooi tannie.
It is a well-known fact that sentence proceedings
Rhetoric in the back.
are the most difficult part of any court proceedings. It does not only affect the accused person, but also the family of the offender, including the society, that being the public welfare, safety concern, and the interest of society. It is also known that a court is obliged to consider the normal aspects of sentence traditionally taken into account before imposing sentence. These aspects being the accused is indeed a first offender before court and has no outstanding or pending criminal matters.
Yeah,
It also includes the possibility of reoffending. I'm not going to elaborate on that aspect. It was done by the defense. It is
These are for the super
noted as
chats
one
that
of
I will
the
deal with later, just to say thank you.
principles to be taken into account. It also includes loss of employment. In this instance, the case law is clear that should sentence result in the loss of
Create your branded portal and onboard clients with a single link. Give each one a multi-brand workspace and
is an inevitable consequence of crime. Oh, loss of employment is an inevitable consequence of crime.
Yes. Well said.
The court is also obliged to consider the family of the offender. This fact was fully discussed in the pre-sentence report submitted by Ms. Thompson, who testified in mitigation of sentence. On this score, I also think it is appropriate to highlight, I do not intend to discuss the depth of the pre-sentence report, as was submitted by the defense in the heads yesterday, orally, that I accept it was an invasion of the accused's personal space. It could never be seen as an easy exercise. And we heard that evidence of Ms. Thompson, I think, in excess of 5 hours on the 23rd of January. And I think that in itself was surely not a experience. So I'm merely going to highlight how I have highlighted the content and then the family, etc. I do not intend to rehash personal circumstances which has been dealt with or heard. Mm-hmm. The other aspect that the court needs to consider is the state of health of the offender, and the court was informed that the accused does not suffer of any medical or physical ailments as per the report.
Okay.
Youthfulness, it is so that the accused is still relatively young.
No severe seculitis. That's not going to work in his favor.
And most importantly, the position of trust. This is one pointer that the court will return to. It requires full reasoning by court, and I will do so during the process of sentencing.
Ooh.
The further aspect is that the prevalence and seriousness of the offense. This is an aspect the court cannot shy away from today, but also requires full reasoning, and the court will do so during the proceeding of the sentence. Those two aspects. The above are but a few pointers traditionally taken into account by courts before sentence, and some require detailed explanation by courts. It is well known that the ends of justice are four in number, being deterring, preventative, reformative, and retributive. In its nature, it however consists of 5 important functions. It should act as a general deterrent. It should also act as a specific deterrent. It should also, or it must enable the possibility of correction. And it must be protective of society.
Talk about his arrogance.
And it must further also serve society's desire that crime be adequately addressed by courts. It is in the public interest that punishment be meted out fairly and without the measure of excessiveness that would mark it as being merciless and unacceptably unfair. The court is mindful that neither the call for true punishment and revenge, neither the cry for understanding must be given undue weight. The ends of justice, as mentioned already, must be given due regard when determining sentence. And it is required that a court should strive to accomplish and arrive at a judicious counterbalance between the elements mentioned and ensure that one element is not unduly accentuated at the expense or exclusion of any other element. It has been often stated in various case law that the sentence imposed should fit the offender as well as the crime. It must be fair to society and blended with a measure of mercy according to the circumstances of each matter. True mercy, therefore, has nothing in common with soft weakness or maudlin sympathy with the offender, since it is a crucial element of our justice system in its own right.
Yo.
It is also not an element that mere lip service is paid to, but indeed a sound factor that each court must consider and which must clearly reflect in the sentence imposed.
Ooh,
However, courts are required not to strive as stated for severity, but neither on the other hand surrender to misplaced pity.
Yes.
And should not flinch from firmness where it is called for.
Yes.
And that a court should be strict enough to ensure that the objects of punishment are adequately furthered, and indicating thereby that crime will be effectively punished. Having said that, this court is well aware that a court should approach its task with a humane understanding of human behavior and frailties. Just a minute. Been talking a lot, just a minute.
It's all good, Tanny Judge. You take your time. Take your time and do the best that you can. You're doing fantastic. Apply the law. And everybody smash the like button. There's close to 9,000 people here and there's only 2,500 likes. Come on. Smash the like button. Subscribe to the channel. Go to the super chat. Drive it all the way to the right to like 2,500 rand. And press enter. Just for the hell of it. No, don't do that. Because you're going to bankrupt yourselves. But super chats welcome. Memberships welcome. Like button smash. And subscribe. Please. Please, please, please subscribe. It'll be greatly appreciated.
I think at this stage, while we are still proceeding calmly, I'm going to deal with general concerns when reaching sentence regarding matters of this nature. Thereafter, the court will deal with the reply to the offense before court or the matter before court.
Take your time, Judge.
It should be noted that crime is inconsistent with the rule of law and the fundamental value of our Constitution. It undermines the constitutional commitment to human dignity and further the achievement of equality, including the advancement of human rights and freedom. Crime is therefore the antithesis of an open, accountable, democratic government as required by our Constitution. Chaskelson P. in South African Association of Personal Injury Lawyers versus Heath and others, 2001, SA 1883, Constitutional Court, 2001, in brackets 1, states that, I quote, elected office bearers and officials in the public service have become one of the most serious threats to our country's well-being, and that is to state the obvious. Although the mentioned case deals with corruption and crimes of dishonesty, it is still relevant to the crime in general, and as far as it relates to public office bearers, as the impact and consequence pertaining to the matter before court today remains the same if not worse.
Joe Dides, thank you for the R1,000 super chat. Bliksem. I'll read all of the comments afterwards. Thank you very much. Insane. And thank you, Adrian Geldenace, for the €22. Wow, insane. Thank you very much. Keep it coming. Keep it coming, everybody.
An acceptable way of life in our country, this being a situation the courts cannot allow or tolerate. The incidents may well be characterized as a pandemic that needs to be recognized as such and requires concerted and drastic efforts to combat it. It is regrettable that too often in South African courts, the so-called, and I quote, non-violent crimes have been visited with lenient sentences due to the classification of no violence, and that perpetrators of these offences are seen as not to be truly criminals or even prison material due to their ostensibly respectable careers and lifestyles.
Yeah.
The above-mentioned case stated on record speaks about dishonesty. However, this court will dare to say that it does not merely refer to related offences such as fraud, etc., but it includes the dishonest character of an individual, indicating that such conduct entails gross breaches of trust.
Blatantly
At the
lying.
beginning of the sentence, the court mentioned the element of trust and that a court should consider before imposing a sentence, and based on the facts of the matter before court, including the circumstances in which the offences were committed, it shouts of the breach of trust and is of great concern to this court today.
Oh, groot kak. Hier kom
The
groot
accused
kak.
is in a position of trust and
Yes.
elected as such by the members of society.
Yes. Groot kak.
The conduct of the accused and the effect of his actions and the impact of the conviction on the accused combined all reflects, contrary to what is expected from our Constitution, the complete absence of accountability and breach of trust by the accused person before court.
Slaan hom, Tannie Judge. Slaan hom. A cruising for a bruising. Hy cruise for a bruise. Dankie vir die super chat. And yes, I'm ecstatic over this. This guy deserved to be in jail many years ago for the shit that he has done to this country. Threatening people's lives, threatening cultures, calling everybody racist,
Going to try
attacking
and
people, inciting violence.
Summarize the response
Go to jail.
to
3
the
to 5
defense
years.
submissions as follows.
3 to 5 years. Smash that like
It must
button,
be
everybody.
noted,
Come on.
and the accused confirmed that the event was planned. Emphasis on the word event was planned. And that it was a unique established tradition planning an event. Firstly, this I stand corrected on this aspect, but what I should have clarified is the following, that this was, according to the knowledge of this court, the fifth birthday celebration was the first of its kind. I do not understand the wording of it was a well-established tradition. We heard that the 10th birthday celebration, what the main feature was, but whether it was an established tradition at the 5th birthday celebration, I'm not aware.
Lies. Papa wag vir
As
jou.
a result,
Oom
it
Pieter
is
wag
a
vir jou.
great concern to this court that an event was planned and that what appears to be the unique feature of the event ended up in the commission of an offense or offenses. Surely this can never ring true. As per the submissions, the court is asked to consider that the accused had planned the event. And then it goes a step further, because contrary to the view of the defense and the view of the state, today it is clear that the planning included that the accused will possess or take possession of a semi-automatic rifle, fire a .223 Remington bullet into the air, thereby
Premeditated.
causing
Premeditated.
possible harm to person or property in
Jail.
a built-up area.
Premeditated.
That it is now called a celebratory shots, that is sugarcoating.
Yes.
Nothing,
Yes.
nothing more, nothing less.
Well done. Papa wag vir jou. Kry die Vaseline se bak of labello. Lapais.
The facts found by court during its judgment,
Oh,
and
look,
this
the
is not
fake
merits.
Jew is entering.
These are facts.
The false prophet.
I'm going from memory. It was the evidence considered was that the accused had decided that the event was planned by the leadership. All decisions were made by the leadership. So there can be no doubt that you are saying the unique feature of the event was committing 5 offenses.
What? Huh?
That is the bottom line.
I know. Tannie judge maak my seer.
Clearly, planning of this nature is in contrast with the law. How can a court of law consider that the actions of the accused did not intend or did not entail the intention to commit an offense?
Lekker. Eina.
It
Tannie
is
maak
not
my seer.
It is not the thinking of the court, it is the facts before court, because that is what happened.
Yes.
It wasn't, as the state correctly stated, an act of an impulsive act. It wasn't as a result of the case law
I feel
we
bad
heard,
for the
an
family.
act of
I
passion.
do feel bad
It
for the
wasn't
family.
anger. It was the event of the evening.
Yes.
And therein lies the difference. It should take considerable planning for an event of that magnitude, and I'm deviating from my written judgment,
Da na na.
of that magnitude,
Na 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 na.
that as to how,
Hey hey hey.
when,
Go to
and
jail.
exactly at what time
Na na na.
you will take possession of the firearm,
Hey hey hey.
where
Go to jail.
you will fire it from, at which point we all know then, Mr. Sneeman, you returned the firearm to Mr. Sneeman. That finding was made by court.
Yes.
The court did not find it was handed to you by Mr. Sneeman. That is what I'll say in that regard.
Yes.
So that, to reason any otherwise is nonsensical.
I pour myself some cool drink. People are rude to me in the chat.
This is a decision that a person made to possess a semi-automatic rifle unlawfully, and including the decision then to proceed and fire the said rifle in a built-up area in a crowded stadium. The decision to break the law has been made, and it was made with the approval of the accused person and the leadership. Since it's confirmed that this was accused had known it was unlawful, he knew that it may cause harm to persons or property, he knew all the above, and it yet proceeded to possess the rifle and to fire the shot in celebration of the 5th birthday celebrations of the economic freedom fighters. Always knowing when this was being planned, arranging this special feature that it is in contravention of the law. And that this decision was made long before the actual event. Such acts can never be condoned by this court in any instance. The court cannot dismiss these actions planned by the accused as mere celebratory shots, and further justify the commission of crime under the pretense that it was celebratory shots. Much has been said yesterday regarding other offenders
Ja, conscious
who
character.
committed acts of this nature.
Smash the like
who
button.
have not
Share
brought
it
be-
far and
has
wide.
not been brought before a court of law. This court is not in a position to answer for those matters. Safe to say, I trust that surely the long arm of the law would reach and bring those offenders or suspected offenders before court. This court can only reply and answer for the matter before it,
He's
not for what has been said was done by Mr.
Moenie begin
ATZ
bid nou
or
nie, is
Ms.
te laat.
ATZ.
Is te
I'm
laat om te
unable
bid.
do so. My
Moenie nou
focus
bid nie.
is on this matter solely.
Jy moes in 2009 gebid het. 2009.
With regards to yes, as this matter has also led, what has transpired is indeed sad. It's a sad day for justice if this is what bringing a matter of this nature to court results in the impact on the interest of society.
And then he wants to say he fights for the poor people. He doesn't give a
And as
shit
I've
about the
stated,
poor.
the courts must protect the interest of society.
Yes.
Not only did it affect those people I've mentioned, courts adjourned early Our court rolls are overcrowded beyond comprehension. Inmates had to be returned to correctional services, leading to the extension of the overcrowding of prisons or correctional facilities. Witnesses who traveled from far, who lost a family member, let us say in a murder incident, they did not get closure on a specific day which was allocated to them for their matter to be heard. They have to come back.
Yes.
So yes, this matter indeed is sad because it has
that
an
woman's yawning.
immense
Are we boring you?
tragic
Are you
effect
bored
on
with
the
your
administration of
sunglasses?
justice and the very interest of society that is to be served by justice and its staff and courts.
He's screwed. Lecture him, Tani Judge. Lecture him. He always proclaims to be for
And
the
that
poor.
is not overemphasizing. That is a fact and a reality.
Yes. Nail him. Nail him.
The court is limited to what you have been charged for, and that is what I'm dealing with. Nothing more. Safe to say then, on what the court has already alluded to, the commission of these offences are not insignificant, and the impact thereof remains the same. Whether it was done in less than a minute, the impact remains the same.
Thanks for the super chat. I'll read all of them afterwards. Thank you. Keep it coming.
Now,
Smash the like button.
this is a difficult matter to raise because it was alluded by the defense that should a custodial sentence be imposed by court, it will show that the accused is singled out to endure a harsh sentence. To this, the only reply from court is, it is not the court who has singled out the accused person. He had done so all by himself.
Yo!
Not the
Tani
court.
Judge! Dropping bombs!
In the light of the position that he holds as the CIC of a political party with massive support, it's not the court who had singled out the accused person.
He's going to jail.
The fact remains there is a significant amount of accountability on the accused.
Yes. Thanks for the super
And
chat.
in this regard, I'll add the following, that please remember, it is not a political party who has been convicted here.
Yes.
It is not the economic freedom fighters that have been convicted.
Yes.
It is a person, an individual, who so happens to be the CIC of a political party.
Yes.
Nothing more, nothing less.
Ooh, she's
It's
prepping him
not
for
the
a jail
party.
term.
It's an individual, and that is how it is perceived.
He knows it. Look in his eyes. Papa wag vir jou. Oom Pieter wag vir jou.
And while I'm on the topic which is uncomfortable for everyone, let us continue with this political trend that is followed. This court heard, as I've stated, plus minus 19 witnesses. Not a single witness testified before this court testified regarding any political facts or that is not facts before court. The evidence, and that's where it ends. A court of law and politics do not blend. The two do not collide. Judiciary stays in its lane. Politicians stays in their lane. The easiest way to explain this is I think the minds of a jurist and the minds of a politician do not function on the same frequency at all. Hence, the court is expected to remain independent, dispense with justice without fear, favor, or prejudice, and that is the duty of this court. The rest is of no interest, only the law. Just a minute.
Thanks for the super chat, Leon. I'll deal with all. I'll read out all the super chats after the judgment because I see some is pissed at me for giving opinions here. This is my channel, okay?
On this
and
topic,
welcome to
I'll end off by
10,000
saying,
people on this live stream. Smash the like button, please,
at all times,
and subscribe to the
the
channel.
judiciary,
Please.
including the
Thank you.
justice system, will never be intimidated by any politically charged utterances or parties.
There we go.
There is
Well
no
said.
room in a court of law dealing with a criminal offense for the court to enter into politics at all.
Danny Judge, 3 to 5 years. He does not lose his parliamentary seat, by the way. If he appeals, he doesn't lose his seat until the last appeal has been lost. So he can remain a member of parliament for the
What is
next 2 to
apparent
3
then
years.
is that people of this country are speaking as one. Crime is reaching astronomical proportions, and the courts are required to do all in its power to combat the situation and to ensure that all would-be offenders or offenders who are still to be brought before justice
She's lubing him up.
faces the full arm of justice.
She's lubing him up.
And surely if this is not done or goes unchecked, as I've stated, it will result in the perception that crime is an inevitable consequence of life in South Africa. It must further be noted, as much as the rights of the accused has been emphasized, and correctly so, as it is enshrined in our Constitution, members of society too enjoy rights, the same rights as enshrined in our Constitution. These rights are not one-sided and enjoyed by all.
Skoon Pepsi. There's no branas in here, by the way. If he gets more than 1 year direct imprisonment,
I'm about to end off. I just want to briefly refer to our engagement yesterday in the oral submissions by the state and the defense regarding the two case laws submitted, one by the defense and the other by Advocate Sisa. Just want to get to the relevant.
so if he gets more than 1 year, he loses his seat in parliament, but because he's going to appeal the sentence, he remains a member of parliament until the last appeal is lost, potentially two to 3 years.
Rights, the same rights as enshrined in our Constitution. These rights are not one-sided and enjoyed by all.
Gewoon Pepsi. There's no branas in here, by the way. If he gets more than 1 year direct imprisonment.
I'm about to end off. I just want to briefly refer to our engagement yesterday in the oral submissions by the state and the defense regarding the two case laws submitted, one by the defense and the other by Advocate Sisa. Just want to get to the relevant.
So if he gets more than 1 year, he loses his seat in parliament, but because he's going to appeal the sentence, he remains a member of parliament until the last appeal is lost, potentially 2 to 3 years. Smash that like button, everybody. Come on, can we at least get to like 6,000 likes? There's 10,000 people watching. Thank you very much. Just smash the like button. It's easy. And then click that subscribe button, and if you don't like my content, you can always unsubscribe later. Just give me a chance. Gee net vir my 'n geleentheid, asseblief. Subscribe. Ek's 'n arm blanke.
Submitted by the state being Romeo Jansen and the state, case number CANR 220/18, delivered by D. Van Zyl, then DJP, and by the defense, that of the Malundana case, case number CC 20/2024, delivered by Brooks J. Now, in this instance, it was interesting to read both. And what is abundantly clear is that in the matter presented, the Malundana case, the facts are completely opposite as the ones we are dealing with today.
Oh,
in the matter submitted, the Malundana matter, was a gentleman of 62 years old who had, after a very long period of time, secured employment as a security officer protecting a school, which led to him firing a handmade firearm. The difference in that matter, which the judges considered as sentence and mitigation of sentence, is the accused there had pleaded guilty. He had also spent a period of time incarcerated, 4 months in custody before. Further, he was also a first offender. He had assisted the victims at the scene, and he himself had called the police to come and assist. He had also contributed to the costs of the family who suffered in the incident. That is the set of facts unique to that matter. Now, what is interesting in the Jansen matter, counsel argued yesterday that the matter cannot be of assistance to the court. I disagree on that aspect. Indeed, it was, because I think it was said that he had previous convictions, Jansen. But when you read the actual judgment, the judge states clearly that the accused was treated as a first offender despite having previous convictions. So that is not relevant. That was, he said, and he was found to be, or having been in possession only.
Thanks,
There
Kyle.
wasn't a crime that was committed on the day he was arrested
Yeah, thank
with
you,
the
Sierra
firearm.
Nasban.
And then interestingly, after being asked by the defense that all people be treated equal, it was submitted that Jansen is a gangster, therefore a member of Fat Boys, and therefore custodial sentence is in order. I failed to see the reasoning and the rationale behind that, but what is evident and clear after discussion of all the cases submitted by the state and the defense, in the view of this court, each case is unique. Every person is equal in law. What does equal mean in my view? That the court should ensure that accused rights to a fair trial is protected and that it applies equally to every individual who appears before a court of law. Sentences, we have this contradiction and variety because, as I've stated, each set of circumstances and facts are unique. If we take, without disrespecting a gangster, we cannot say for gangsters, right, there's a sentence of 5 years.
That's what I said in my
For
video
politicians,
today.
it should be 6 years. For
That's
the
what I
homeless
said.
person, it's 10 years. No, no.
That's what I said. Thank you,
It's
Judge.
done
Thanks, Tani
in
Judge.
its totality. And unfortunately, the accountability on a public office bearer
I said that too.
is a lot more. It weighs heavy than
Yes.
that of the regular South African person.
Preach, Tani Judge. Preach.
So by saying that, that doesn't mean you are not treated equally or the accused is not treated equally. That is not what equality, in my view, portrays.
Oh, so a backcourt jam, Tani Judge.
I'll end
Tani
it.
Court 'n triple brana na hierdie een. Aman klap, Tani Judge. Aman klap. Long leave, Tani Judge. Long leave. Long leave. Kiss the Tani, the Judge. Brr, pa, pa, pa. Kiss the Tani Judge. Brr, pa, pa, pa. In celebration. Long leave, Tani Judge. Long leave. Come on. Give it to us.
Just a minute.
Wat kyk jy? Wat kyk jy?
Nee, dan just a minute.
Moenie vir my so kykie hoor. Jou krimineel.
Worship, if I may at this stage, I'm so sorry about this. I need an urgent comfort break, Your Worship. I've been sitting here since 7:30 this morning, Your Worship. I'm so sorry about that.
I'm going to single you out, Advocate Caesar.
Yes, Your Worship. I tried my best to not.
So I was perusing the file to end off, but okay, can we then say, I'm sorry for this then, but instead of 5 minutes, it's a large crowd. Shall we say this is then the tea adjournment, we come back, we continue then thereafter? I'm sorry for this. No, Advocate
Laat hom suffer.
I cannot, just now we all drown when that man
Oh,
cannot.
don't shake your head. You had 8 years. You had 8 years.
Please, I'm going to, just a minute. Sorry, feel free.
What time, Your Worship?
I'm going to leave this now.
What time?
I'm not going to take it with me.
What time are we coming back?
It's 25 past. Can we all agree, due to the amount of people who may also need the facilities and who need to go out and come back in, is quarter to 11 in order?
Yes,
Yeah.
please, Your Worship.
I'm even asking the gallery sufficient time to come back and continue. Yeah.
Ish. I'm starting to think that 3 to 5 years were maybe a little bit conservative after what she said over here. Huh? Ek dink daar kom 'n lang sentence for him. Okay, so I will switch over. I've got it here. As soon as I see some movement, then I'll make a plan. But let me just quickly deal with a couple of things here, right? So let's assume that he will get a jail sentence today, right? He's not going to go to jail immediately. He's already said that he's going to appeal the sentence. He's also not going to lose his job as a member of parliament because he said that he's going to appeal. Now, the options with the appeal is that he can appeal it to the High Court for a full bench of judges. They can reject the appeal, and I think that they will, based on the hard work that the judge did today and throughout the court case, the magistrate rather. So I don't think that there's a real success for an appeal, but it could still take time because they can review it. So then there is the High Court that can say yes or no. Then there is the Supreme Court of Appeals that can say yes or no. And I don't think that there's any real success at trying to take this to the Constitutional Court because it's not a constitutional matter. So the only two courts that he can realistically appeal to is he can appeal it to the Magistrates Court, which I think will, like, she'll just say, I deny it because I came up with the judgment. Then the High Court can deny it, and then the Supreme Court can deny it, and then he has to go to jail. Then he loses his parliamentary seat, and he has then direct imprisonment. So those are the things that will take place. Okay, can I just quickly, we are waiting. Toy a donor, I just saw 1,400 Rand super chat. You guys must calm down, eh? It's the middle of the month. It's the middle of the month. Moenie mal raak hierso nou nie. I don't want to hear complaints at the, towards the end of the month. We're like, oh, ek het niks geld nie. Oh, salty cracks. All I have to do is eat salty cracks. Julle gaan mal met die super chats hierso. I'm not complaining, but you are going to complain at this rate. Okay, so let's run through the super chats quick. The court will resume at 10:45. So, and then I think it'll be quick when a judgment is heard, right? So, Dion Fritz, thanks for the 35 Rand. Graham, thanks for becoming a member. Uranyaman, thanks for the 14 Rand, saying, Mora, 3 to 5 years suspended for 5 years and maybe a fine. It looks a lot worse than that at the moment. Theo van der Walt, thanks for the 14 Rand. Joe Dides, thanks for the 100 Rand, saying paying his lawyer with VBS bucks. No, that money was spent long ago. You can forget about that. Cheryl David, thanks for the 14 Rand, appreciate it. Andre Farmer gave a 70 Rand, saying dankie vir jou tyd Ronaldo en die moeite wat jy insit. Ag, ou chomma. Dis net 'n plesier, jong. Is net 'n plesier. Jy weet, veral in sulke lekker dae soos vandag wat jy 'n bietjie kan lekker kry. Because don't forget, right? They had a lot to say when my membership with the DA was terminated and I lost my seat in Parliament, right? The EFF had a lot to say. Now I've got a lot to say, so it's fine. At least I'm not going to jail. At least I'm not a convicted criminal. At least I don't sing songs about killing people, right? Lisa Fulyoon, thanks for the 35 Rand super chat, saying we need a solid example. And he is the best candidate, holding thumbs for 15 years in jail for juju. Thank you. I don't think it'll be that much, but hey, I think any jail term longer than a year is worth it. Ria Bunny gave a 14 Rand, thank you. No Lavishness gave a 14 Rand. GTP Keeper SA gave a 35 Rand, saying appreciate all the work you do, Ronaldo. You are a true South African. Thank you very much. Some people think that I'm not, but whatever. I appreciate it. Leno Hartzenberg gave a 50 Rand. Thank you. Appreciate it. Tracy Siberini became a voortzekker. Thank you. By the way, I appreciate members because you get perks, you get early access to videos. So if you would like to support this channel, become a member. It'll be greatly appreciated. Ben LaRue renewed his voortzekker membership. Thank you very much for that. Liquid Rhino Gaming gave a 50 New Zealand dollars. Wow. Wow. Saying, wat dink ons gaan die poepeltronk toe? Of wat dink ons gaan die poepeltronk toe? Nkandla maak my worry. Groete van New Zealand. No, don't even worry about that. He doesn't have the same pull or power than Jacob Zuma. And he said that he's perfectly fit. So there's no Shabir Sheikalitis that's going to pop out of the woodwork. But thank you for that very generous super chat. Ben LaRue, thanks for the 14 Rand. Jan Sneyman, thank you for the 70 Rand. Andre Skeepers, thanks for the 14 Rand. Benny Nixon, thanks for the 40, whatever that currency is. Malema, enjoy the jail. Well, thank you. Bumblebee Tuna ZA gave a 35 Rand, saying cheers. Well, thank you. I appreciate it. Eureka Rosentrauch gave a 35 Rand super chat. Siamas Baan gave a 14 Rand, saying so Bikkie, Zambak and Snuif. What do you guys think he should get? Zambak, lip ice, or Vaseline or deep heat. I'm just saying. Gee hom 'n bietjie deep heat. By die chommy. Sit 'n bietjie deep heat daar by die chommy. Dan gaan dit nie lekker werkie. Hey, nah. Benny Nixon gave another 100 of his currency saying, look at his face, no guilty, no remorse, what kind of person he is. Bye-bye, Malema. Enjoy the prison. Thank you. Andries, thanks for the 20 Australian dollars. It's greatly appreciated. Thank you, Andries. And then Joe Dides gave 1,000 rand super chat. Nee, jy het te veel geld hoor. Ek dink SARS moet jou 'n bietjie investigate. Did the crime, do the time. God is good. Thanks, Ronaldo, for hosting. Great job, brother. Well, thank you. Appreciate that 1,000 rand. But I'm going to phone SARS. Just give me a second here. Hallo. Ja, ek wil asseblief vir Joe rapporteer. Die man gee 1,000 rand super chat in die middel van die maand. Ja, ek dink is 'n groot probleem. Ja, Joe Dides. Soek hom met 'n bietjie op, hoor. Okay, ja. Nee, moenie worry oor my nie, ek's fine. Nee. Wat's my naam? Toe maar. Hey, Adrian Geldenhuis, thanks for the 22 euros, saying, ag okay, as ek nou regtig moet, ek wil jou wel ontmoet wanneer ek terugkom Suid-Afrika toe in September. Well, if you're close to Port Elizabeth, just pop me an email. It's easy. Sumari C, thanks for the 100 rand. Go Tanny Judge, yes, Tanny Judge. Thanks, Adrian, for that very generous super chat. Thanks, Sumari C. Nicholas Groves, thanks for the 14 rand, saying lip ice won't keep the chaps off, or the herp. Looks like he's got a couple of herps over there. Benny Nixon, thanks for the 41. Life imprisonment or 15 years in prison. I think he's going to get 3 to 5, maybe 7 years. Charmaine says hy lyk soos 'n skaap op 'n scrambler. Sorry, Jujuchi. Thanks, Charmaine. Andre gave 100 rand. Thank you very much. Karatinarki, Karatinarki, wow, what a name, gave 140 rand, saying, ooh, the chest pain is sitting on the lip. The pain is straight to the heart. Ola accountability, ola justice, wat jy saai, sal jy maai. Sorry. Leno Hartzenberg, thanks for the 100 rand, saying, lekker Tanny Judge, exactals. Leon, 14 rand. Viva Tanny Judge. Viva. Long live Tanny Judge. Long live. One Leslie Ann gave a 35 rand, saying, what a treat for a Thursday morning. Your commentary makes me laugh out loud. Thanks, Stack. Well, you have to laugh in this environment. But today's a good day for South Africa. For all South Africans. Believe it or not. For all South Africans. Especially the cultists out there. Dystopian Phantom, thanks for the 35 rand, saying Juju moet stopprop van woodwork maak om enige gevare van agteraf te voorkom vir sy safety. Thank you. Lindy Jordan, thanks for the 350 New Zealand dollars. It's appreciated. Carl Reeler, thanks for becoming a member. Siamas Baan, thanks for the 14 rand, saying Tanny Judge. Francois Jordan, thanks for the 14 rand. Oreos are not biscuits. Thanks for the 35 rand, saying Tanny Judge is slow roasting him. I love it. She is, eh? She is. Sy vat die kakkie hoor. She's not taking any cock. Joe Dides, thanks for the 40 rand. It's appreciated, buddy. You're giving a lot of super chats here. Nicola Scholz gave 140 rand. Thank you very much. Saying Tanny Judge is doing the Lord's work. Well, this should have been done a long time ago, but thank you for the super chat. Lindy Ordon gave her another $3.50, and then Francois, wat gaan aan so Francois? Hey? Francois Dupree, 1,400 rand super chat. Hi, this is another anonymous person. I'm trying to report Francois Dupree to SARS for investigation. Yeah, he gave 1,400 Rand super chat in the middle of the month. Please just check. Yes. Who's speaking? None of your business. Los my uit. Ek betaal my tax. Ryan, thank you for the 35 Rand. Okay, but seriously, Francois, wow, dude. Thank you for the 1,400 Rand. That's absurd. Jy het te veel geld. Jy moet minder geld maak, hoor? You're making the rest of us look bad. Okay? Ryan gave a 35 Rand super chat saying, love the wall in the background. Where do you get the vertical neon lights? Been looking for ages. That's Timu. Is it? Timu. Yeah. That's Timu. This is Timu. That's Timu. That's from YouTube. Thank you for the super chat. Ian Martins, thank you for the 350 Rand. Just, waar kry julle mense al die geld? Waar kry julle al die geld? Nee, bliksem. Ek was nooit in politiek ingegaan het nie. Julle maak te veel geld hierso. Carol Snyman, thank you for the 200 Rand. Elise Fourie, thanks for the 140 Rand. Zan Donuts, thanks for renewing your membership. It's greatly appreciated. Snackies for the hoinkies, say Madeleine, thank you. Recon One Outdoors gave us 70 Rand, saying thank you for all the hard work over the years to build this channel so we're able to witness these moments on this platform of yours. Truly amazing what you've built. Well, thank you, Recon One. I appreciate that. And listen, can I just say, and to everybody watching here, if you like those outdoor ASMR channels that is usually from overseas people, please go and check Recon One Outdoors' YouTube channel. The video production is amazing. It feels like you are there with him camping. It's amazing. And the food that this guy makes when he's camping outdoors is insane. So Recon One, please post your link. And also all the people that are here that has got a YouTube channel, you know, the Mork Rock Show, Matthew Cohen Power Pod, everybody that's here that I might have missed, please post the link to your channel. Let's support South African content creators. Let's grow this thing where we put the United States YouTubers and YouTubers around the world to shame, because we've got a lot more talent than those people over there. So please go and support local. Smash the like button over here. Subscribe to this channel. It'll be greatly appreciated. Thank you very much. And thank you, Recon One. And thanks for the awesome videos that you also produce, buddy. Alex Davids, thanks for becoming a member. Waldo Lion Gaming, thanks for the 35 Rand, saying, denk jy hy sal in 'n gewone tronk sit of is in sy eie luxe kamer? I don't care. I don't care. As long as he's in jail. That's it. They can give him a queen-size bed. They can give him a TV. They can give him a laptop. It's fine. As long as he goes to jail. Because for the last, well, for his entire life, he's thought that he was above the law. Look at his arrogance. Don't have time for that cock. Go to jail. I'm not going to say this guy's name, but thanks for the 69 Rand. P Hall of Fame. Yeah. Thank you. Garrick van der Nest, thanks for the 30 Rand. Charles Leroux, thanks for the membership. Alex Lemon, thanks for the 40, whatever the currency is there. Julius had to take a cock, hence the break. And then Recon One gave a 35 Rand super chat with his YouTube channel link. Click on that link, everybody, please. Click on that link. Subscribe to him. It'll be greatly appreciated. All right, let's just quickly, let's just quickly see what's going on over here. You know, like just to get you guys ready, because the court resumes in 5 minutes. So with that being said,
Malema, sê maar vir jou grandma. Môre gaan jy tronk toe, boeta. Klein man wat groot wil speel. And a little man want to play big games. Klein man Malema. Little man Malema. Bedorven brat met rooibaret. Yes, you with the red beret. Lieve uitspraak elke dag. Hate speech every day. Allemaal wat niet saamstem nie. Anybody who disagree, you chase away. Jy skree en skel, you shout and scream, call names, want allemaal moet luister, maar niemand hou van jou nie. Ja, nobody likes you. Jy so alleen, sad little man. Hey, jy love your mic, love your drama, love to spread the fire. Hate everybody who don't clap when you say revolution, high of it. Swart in die color, as hulle nie klap nie, then they're the enemy. Maar as die hofbel when the court calls, dan huil jy, they're picking on me. Bedorwe klein vriendkie, ja, spoiled little boy. Gooi tantrums op die vloer, rooi oorpak, red overalls, groot stem, big voice, maar binne is jy net rage en haat om geld te maak. Jy wil die grond hee, you want the land. Jy wil die mag hee, you want the power free. Maar echte leiers, boy, you hear me, real leaders build. You only know how to disagree and to break. Klein man, Malema. Little man, Malema. Bedorwe brat met rooi baret. Yes, you with the red beret.
Luister. Ek sta oud vir dans. Yo, when I was a DJ, you never dance. You can see I'm not a dancer. Donnie, thank you for the 350 Rand super chat. Appreciate it. Saying Judgment Day. Great work, Ronaldo. Thanks for the live feed. It's my greatest pleasure. Bliksem. Wat gaan aan? Die man kan nie meer dans nie. Ek kan nie birds vang met hierdie dance moves nie. Pete gave a 25 Rand super chat saying Tanny Judge is not selling us out to gangsters. Exactly. And 8 Your Chips gave a 35 Rand super chat. Thank you. Saying Oom Pieter sal baie goed na hom kyk. Oom Pieter het klaar die deep heat georder. Die deep heat is klaar georder. Yolandi Van Vieren. Hallo Tanny. Dankie Oom Ronaldo. No, thank you to the Van Vierens for always supporting this channel. Greatly appreciated. Reese gave a 200 Rand saying get a room. Fluikie and Mork. Oh, what are they doing? Wat gaan nou aan? Huh? You, maar hy het gestuur nou na my stream, het jy deurgekom, Draadman. Oh, okay, never mind. I don't know what you're saying. Thank you for reminding everyone who is holding a criminal politicians to account. Can I just say this quick, right? How long do we have? It's probably a minute. So this is a very important thing. Conscious Caracal, I want you to spam the chat with 10 links. This would not have been possible if not... Hey. Focus. There's 8,500, and listen, I want to be clear, right? We would not be here right now if it wasn't for AfriForum. The government and mainstream media despises AfriForum The government and mainstream media despises AfriForum because they hold the This is a very important thing. Conscious Caracal, I want you to spam the chat with 10 links. This would not have been possible if not... Hey. Focus. There's 8,500, and listen, I want to be clear, right? We would not be here right now if it wasn't for AfriForum. The government and mainstream media despises AfriForum because they hold the government time. government. It pisses off mainstream media, and it's the right thing to do. So thank you, Conscious Caracal. There we go. Slate on, join, and make a difference. If you want to donate to them, donate to them. It's because of those donations that Julius Malema today will more than likely get a direct imprisonment sentence. And while you're at it, as we wait to hear what's going on here, I've pinned a message. If you are hurtful of the DA and their woke ideology, as you can see how they are moving further to the left with their new leader saying that he does not support Donald Trump or MAGA and what is happening in Iran, I've posted a link here that is from the Freedom Front Plus. You can sign up to become a member. If you are a conservative, if you are a person that puts God first, that loves this country and wanted to thrive, you think a family, the family unit is the most important thing, and you love your freedoms, then join the Freedom Front Plus. Because unlike other political parties, we stand for conservatism and for family values and for language and culture of all groups, not just some. Anyway, link is there. Click on it, and I will deal with all the super chats after because the judge is back. So let me just get this ready over here, and then we can go back to the live stream as soon as it's back. But yeah, I'll deal with the super chats after this. I'll do the hearts to say thank you. But then after the stream, I've confirmed Rob Hersoff will come on. He would give us, he's going to give us his take on it as well. But then also, I will deal with the super chats. And maybe if Conscious Caracal is available, we can take it from there. But here we go once again, ladies and gentlemen. Here we go. And now? Okay.
All right. I will then proceed, and in summary, just add the following. That also keep in mind the magnitude of pronouncing the sentence is that we should also keep in mind that we've heard daily or weekly of children playing in their front yards in the street who are caught in crossfire, random shots fired, killing people. It's just the first time that we hear it's being called celebratory shots. And in essence, the accused, all as stated are equal before law.
Yes.
But in your instance, it cannot be said that you are not accountable due to the position you find yourself in. You are accountable to members or citizens of this country, to your followers, to the youth. And that accountability stems from your position. And that is where I'm going to end this.
Oh, here we go. Here we go.
Please stand up.
Come on. Come on, Tiny Judge.
Not the court. Oh, I'm sorry. Maybe I should be clear. Okay. Sorry for that. All right. After careful consideration, and I can show you I have done so, free of any interference, this judgment or sentence is the sentence of this court and this court alone. In respect of count 1, you are sentenced to a period of 5 years imprisonment. In respect of count 2, you are sentenced to a period of 2 years imprisonment.
Oh.
Respect of count 3, you are sentenced to 20,000 rand or to undergo 6 months imprisonment. In respect of count 4, you are sentenced to 20,000 rand or to undergo 6 months imprisonment.
Oh.
In respect of count 5, you are sentenced to pay a fine of 20,000 rand or to undergo 6 months imprisonment. In terms of Section 280, subsection 2 of Act 51 of 1977, the court orders that the sentence imposed in respect of counts 2, 3, 4, and 5 run concurrent with the sentence imposed in respect of count 1.
As the court reinstated.
You may be seated. Thank you.
Oh shit! Oh shit! I called it! Yeah!
May we, Advocate Otis, sorry,
That
not to interrupt you, may we just deal with the Section 103 inquiry, and then we can proceed to that part. I assume you are ready for that part as soon as we've dealt with the 103
5
inquiry.
years, baby. I called it.
Certainly.
I gaan met jou lippe. Sis. Hou dit weg van my. Brr, pa. Pa, pa. Brr, pa. Pa, pa. Go to jail, Malema. Brr, pa. Pa, pa.
There's a brief explanation to just, unless it's not clear, the next step of the sentence is that the court is obliged to deal with the provisions of Section 103, subsection 1 of Act 60 of 2000, meaning that the determination of unfitness, as I've explained in the beginning of the sentence, should not be made separately before sentencing, as information relevant to such fitness may emerge during the process of mitigation or circumstances. And the inquiry in terms of Section 103(1) Act 60 of 2000, since in terms of Section 1, the accused is deemed unfit to possess a firearm or license in future by virtue of having been convicted of a crime specified in Section 103, subsection 1 of Act 60 of 2000, and reasons may therefore be advanced or evidence presented to enable the court to consider the possibility of determining otherwise. So, Advocate Otis?
So if I leave it in the hands of the court,
No submissions.
the accused does have a firearm license, and the court is released.
Well,
Thank
bye-bye
you.
firearm
Advocate Sisa,
license.
on behalf of the state?
The accused should be declared unfit to possess a firearm.
I declare today a public holiday. We call it Malema Free Day.
Due to the reasons provided by court during sentence and that we are dealing with unlawful possession, due to the virtue of the nature of the offences, the court therefore makes no otherwise order and you remain to be deemed unfit. And it is followed by the following further order by court. That Section 103, subsection 1, read with the provisions of Section 104 of Act 60 of 2000, the accused then remains to be deemed unfit, and the effect of the declaration of unfitness is as follows. All competency certificates, licenses, authorization, and permit issued in terms of this Act to any person who becomes or is declared unfit to possess a firearm in terms of Section 102 and 103 cease to be valid from the date of the conviction or the declaration, as the case may be. B, despite the noting of an appeal against the decision of a court or the registrar, the status of unfitness contemplated in paragraph A remains in effect pending the finalization of the appeal. Further, a person who becomes or is declared unfit to possess a firearm in terms of Section 102 or 102.3 of Act 60 of 2000 must within 24 hours surrender to the nearest police station all competency certificates, licenses, authorizations, and permits issued to him or her in terms of this Act, all firearms in his or her possession, and all ammunition in his or her possession. Therefore, it should be noted that subject to the provisions of subsection 9, subsection 3, subsection B, and after a period of 5 years calculated from the date of the decision leading to the status of unfitness to possess a firearm, the person who became or becomes or deemed and declared unfit to possess a firearm may apply for a new competency certificate,
5 years
license,
later.
authorization or permit in accordance with the provisions of this Act, being Act 60 of 2000, the Firearms Control
5 years
Act.
later. Yeah.
Yes, God please.
All right.
What now, Julius? Hey? What now, buddy?
So what we are left with is the application. Are you ready to proceed now? Okay. Let me just get that part of it.
What now, hey? Shame, please. 5 years, hey?
Appeal against conviction and sentence and the application for bail pending the outcome of the proposed appeal.
Yes.
If the relief is not granted, then it will be bail pending the outcome of the petition.
Tunny Judge.
Just,
Well done.
just a minute, Advocate Orders. I just want to quickly grab the notepad. I haven't drafted that, so I'll have to listen to you carefully here. Just a minute. Okay. Thank you. Yeah, I'm ready.
Thank you. So this is an application for leave to appeal in terms of the provisions of section 309(1) and 309 capital B of the Criminal Procedure Act, 51 of 1977, which provides that you can commence immediately by oral address, provided you list all the grounds. So it's an application for leave to appeal to the High Court of South Africa, Eastern Cape Division, held at Grahamstown, against the whole of the judgment convicting the accused of, firstly, unlawful possession of a firearm in contravention of Section 3 of the Firearms Control Act 60 of 2000, to wit a .223 Marinka rifle and or a firearm the make of which is unknown to the state without holding a license, permit or authorization. The second count, Your Worship, that we seek leave to appeal against is unlawful possession of ammunition in contravention of Section 90 of the Firearms Control Act 60 of 2000, to wit a .223 Remington bullet.
No, it's just random stuff. Joe Dides, thank you for the 2,000 Rand super chat. Wow, Branas vir almal by Ronaldo se huis. Bel maar vir SARS. Ek is 'n eerlike man. Dude, thank you so much for the 2,000 Rand. That is insane.
A built-up area
Thank
or
you.
any other place in contravention of Section
Thank you, buddy.
120(7)
Wow.
of the Firearms Control Act 60 of 2000, to wit the Sisa Dukashe Stadium in Mdantsane. The fourth count, Your Worship, is unlawful failure to take reasonable precautions to avoid danger to a personal property in contravention of Section 120 sub 3 sub C of the Firearms Control Act 60 of 2000, in that the accused had control of a loaded firearm, to wit a .223 Marinka rifle and or a firearm the make of which is unknown to the state, in circumstances where it created a risk to the safety or property of the general public attending the 50 km freedom fighter celebration. And finally, the fifth count, Your Worship, is reckless endangerment to a person or property in contravention of Section 120 sub 3 sub D of the Firearms Control Act 60 of 2000, in that the accused unlawfully discharged or otherwise handed the firearm to wit a .223 Marinka rifle and a firearm the make of which is unknown to the state in a manner likely to injure or endanger the safety or property of the general public attending.
Can we just get some hearts in the chat for Tunny Judge? Like, I mean, imagine the pressure that she was under, and then she just still applied the law. Like, this, I know how we all feel about Julius Malema, but if you just apply the law, this should have happened, and this is right. So well done to Tunny Judge for not falling for political pressure, and may God, you know, just carry safety over her during this time.
Having acknowledged that the court was obliged to evaluate circumstantial evidence in this matter, the court had regarded to the often quoted dictum in Red versus Blom and held that there are two cardinal rules of logic which cannot be ignored. And there's a quote from the Worship. There are firstly that the inferences sought to be drawn must be consistent with all the proved facts, and secondly the proved facts should be such, and the Worship said, I quote, that they exclude every reasonable inference from them save the one sought to be drawn. Yet, we say, Your Worship, that Your Worship, the magistrate, committed a material misdirection not having any Alternatively, sufficient regard to all of the facts that militated against the guilt of the appellant, of the accused at this stage. We say that this occurred despite, Your Worship, the magistrate having held, and there's a quote here, Your Worship, the court must not take each circumstance separately and give the accused the benefit of any reasonable doubt as the inference to be drawn to each one so taken. It must carefully weigh the cumulative effect of all of them together, and it is only after it that it has been done so that the accused is entitled to the benefit of any reasonable doubt which it may have as to whether the inference of guilt is the only inference which can be reasonably drawn. To put this matter in another way, the state must then, as stated, satisfy the court that each separate fact is, let me rephrase as stated, the state must satisfy the court not that each separate fact is inconsistent with the innocence of the accused, but the evidence as a whole is beyond reasonable doubt inconsistent with such evidence. Yet we submit that Your Worship committed a material misdirection not having any alternatively sufficient regard to all of the facts that militated against the guilt of the accused. In this regard, we say further that Your Worship further urged in holding that, and there's a quote, a number of circumstances, each individually very slight, may so tally with and confront each other, leave no room for doubt of the fact which they tend to establish. They each taken by itself, but as light as a dot, however, joining together, you'll find them pressing on the individual with the weight of a millstone. And we say that you further urge in this regard.
What is he doing now? Can somebody just tell me? Because he's rehashing the case. Like, is this the appeal process now?
And circumstantial evidence alone varies infinitely in its strength in proportion to the character, to the variety, to the independence one of another, and one might describe it as a network of facts cast around an accused person. That network may be as strong as it is important.
Deny the appeal, Judge. Deny it.
Allow the accused person safe passage. It may be so close, so stringent, so coherent in its texture that no efforts on the part of the accused can break through. It may also come to nothing, and or on the other hand, it may be absolutely convincing. The law does not command that you should act upon certainties alone. We often ought to act upon just and reasonable convictions founded upon just and reasonable grounds. The law asks for...
This is a cock feeling, eh, Malema? For once, you can't just do whatever you want. For once, there's consequences for your actions. And say goodbye to the EFF, because now everybody's going to hunt for your position. Bye-bye, EFF. Good riddance to bad rubbish. Bye-bye.
So the court mentioned that only paid me a lip service to the issues raised in argument on the merits on behalf of the accused, did not have sufficient or due regard thereto. In this regard, the court mentioned the 23 statements by the investigating officer, Colonel Swartboy, the lack of DNA or fingerprints linking the accused to the firearm, no eyewitness complaints, and various other factors relating to a 9mm Glock firearm and ammunition.
There was a video.
The court did not take these factors into account.
There was a video.
Two cardinal rules relating to the admission of circumstantial evidence. Go further, which would say, additionally, the court's assessment of the circumstantial evidence and acceptance thereof did not have regard to the absence of any damage to any structure and the inability to link the suspected firearm and spent cartridge to the accused. Other significant facts in this regard were that no person reacted in fear, and the 5 VIP SAPS members had not witnessed any shooting.
Okay. I'm sorry if you can just mark there where you are busy with. She's informing me that there's a sound coming that she needs to check from our court recording machine, and I just please don't want anything to go wrong with our recording of the stage of the proceeding. So she's asking that we just adjourn for her to check and that all cables etc. are in place. I'll just leave, please. I'm not going to pack up everything, just leave it here, and then I'll be, when you're ready, they'll indicate to the police and I'll enter. Thank you. Court will adjourn.
Yeah. Let's see if we can hear anything. Yeah, look at you. Look at you now, buddy. Yeah, I'm missing. Ah. Has the reality set in yet, buddy? Hey? You're going to jail. You can appeal, but it's going to bug you every single night. It's going to bug you. It's going to bug you non-stop. Non-stop, buddy. Okay. Let's see what are they saying here on SABC? Is there anything going on? No. Okay, let me go through. Are they saying anything here? Let's just listen. If anything is being said, doesn't look like it. Oh, shame. Is the riots going to start now, or what's happening? Tell me about the riots. All right, so I just want to quickly get through some of the super chats here. Where did I go? Eat your chips. Thank you for the 35 Rand saying Oom Pieter sal baie goed na hom kyk. Saskia guy, thanks for the 40 Rand. Desmond Diaz, thanks for becoming a member. Tyron Kutsia, thanks for the 70 Rand saying Aitsa, kom dans vir ons jong. Dink jy die judge gaan 'n escort huis toe nodig hê? Papa wag vir hom. Thanks. Machete, thanks for the 15 Rand saying, is that the AI generated song? Yeah, I think so. I believe so. I'll share the link just now. Is she talking now? Because I can't hear anything. Yeah. There's actually nothing being said. I don't know who she's talking to then. Jakes gave a 400 Rand super chat. Thank you very much for the 400 Rand super chat saying Tannie Judge vat hom droog. Ek hoop hulle kan ook coinage Joel met hom soos daai ouens op Grimsby Brothers. Reese, thanks for the 200 Rand saying, oh yeah, I've already done this. Oh, did I do all of these? They're not unemployed, paid by EFF to protest. Oh yeah, that's also true. Dani Pret gave a 70 Rand saying, bye-bye, dankie Ronaldo. No, thank you to you. Jan Snyman, thank you for becoming a member. Oranjeman gave a 35 Rand saying, ons love Afriforum, hulle is ons toekoms. Agreed. Rulani Klein, thanks for the 70 Rand. Appreciate you. WJ, thanks for the 35 Rand saying, thanks for all your streams covering the absolute comedy of a government and politicians we have in this country. It's my greatest pleasure. Thank you. Johan Groblaar, thanks for the 35 Rand saying, ons gaan nou braai. Yeah, take off work. Say, I'm sick, ek gaan huis toe. Ek gaan nou gaan drink. Wimpers, thanks for the 140 Rand. Kan ons die public holiday maak? It's Malema free day. Malema free day because he's not free. Malema free day because not Malema freedom because he's not free. Tony Nagy, thanks for gifting 5 memberships. It's greatly appreciated. Thanks, Tony, for gifting 5 memberships. tips. Alex Lemon, thanks for the 40, saying time for Juju to call Diddy for that baby oil. No, he's got deep heat. Don't worry, he's got deep heat. Adele Standard, thanks for the membership chat, saying Tani Judge. Chat saying Tani Judge. Agree with oom Pieter, wag vir jou pappie. Ek sal vir jou overall betaal en al vat die geld en koop Vaseline vir hom. And I'll buy some deep for him. I'll buy some deep heat for his chommy, so he can put it on the chommy. If you don't know what a chommy is, it's that little space between your bum and, yeah, the kahunas. Colby Werrett, thanks for the 350 Rand super chat. Greatly appreciated. Lekker big super chat there. Leon, thanks for the 14 Rand, saying, will Adams be available for a discussion later? I did tell him that I would like to host him as soon as, because I want to see whether Julius will speak if he's not incarcerated. So let's see, because he's going to call the judge a racist. I'm 100% convinced of that. Clinton Lester, thanks for the £5. It's greatly appreciated. And Fred, thanks for the 14 Rand, saying just joined. What was the outcome? 5 years of direct imprisonment and 20,000 Rand fines on all the other charges. And then there was another 2-year sentence that's supposed to run concurrently, if I'm not mistaken. Hey, Chris King with 1,000 Rand, saying donkey. No, you guys have got way too much money. I'm definitely in the wrong, like, I know that I'm in the wrong industry here. Yeah, Chris, in the middle of the month with 1,000 Rand. Yeah, Chris. Thank you very much, Chris. It's greatly appreciated. Thanks for all the super chats. Thank you, thank you, thank you. We are waiting for the judge to come back to discuss further the appeal process. And Hale Wolf gave a 14 Rand, saying, effing finally, Faton Fluffy. Thanks for that. And Timo Ryan, thanks for the 14 Rand. Appreciate it. When the judge, okay, are you ready to resume? Where's the cameraman? Okay.
Clear. Thank you.
The next point that I wish to make is that the court summarized the facts in dispute and held that it all announced whether the firearm that was fired on the night in question was a real gun or a toy gun. This issue is not resolved beyond reasonable doubt by the evidence led in this matter. Consequently, the accused was incorrectly convicted of the charges. Then the court further erred in allowing the viral footage to be viewed without it having been authenticated. In this regard, the court took issue with the defense having relied on the footage during cross-examination of state witnesses and the presentation of the accused's case. The court subsequently held the facts which the court will rely on without giving any real regard to the viral footage and no further findings required regarding the said footage. So what we're saying is, Your Worship said it's real evidence, it was allowed, it was referred to, and eventually Your Worship said it's not inadmissible, it hadn't been proven. Then we say the court further urged in having regard to the state witnesses en masse and holding that they were credible, reliable, and truthful. And the court cannot find any bias, prejudice, or any motive in the evidence of any of the state witnesses to indicate otherwise. This was premised upon the court having been very impressed by Colonel Godleka, who was described as being a brilliant witness and had left no stone unturned. He had dotted every T and dotted every I. He had not made any mistake as far as the custody chain or the handling of the exhibits or serial numbers contained. The court finds him and all the above then as stated credible, reliable, and truthful. The extent to which the court had been impressed by Colonel Godleka was further evident from the finding that he meets the criteria, in fact exceeds the required criteria in his thoroughness, and he can be, or is mentioned by this court to be not only an expert witness but a super qualified expert witness. That is the conclusion regarding Colonel Godleka. This evaluation was in turn projected by the court to the rest of the state witnesses, even though there was no factual basis to do so. This in itself indicates a material misdirection by the court in its approach to the evidence of the state witnesses and the assessment of their credibility. In contradistinction, the court held that the defense witnesses, including Mr. de Klerk, were defensive and at stages argumentative. This is further borne out by the comparative analysis by the court of the evidence of Mr. de Klerk as compared to Colonel Godleka, which was found to fall short and only be noted as mediocre. This biased approach to the defense witnesses is further illustrated by the approach adopted towards the accused. The fact that he had stated that Mr. Mavundla should have been charged was utilized to discredit him. Additionally, he was found to have evaded many questions that had warranted a reply. And the court held that it became evident that the replies were entertaining, but however the pertinent questions asked remained unanswered. He was further criticized for relying upon the viral footage whereas nobody else was. Having held that the court had to establish whether the version presented by the defense was reasonably possibly true,
I did mention Chris King,
the
yes.
statement in cross-examination that the firearm had been in Gauteng. In this regard, the court held, and I quote, "Now as to what happened and where it was kept, no explanations provided. It begs the question, dealing with circumstantial evidence, that what does the firearm being booked out to Mr. Mavundla in effect equates to that specific firearm is booked out to him for whenever it is needed for him or by him. Since clearly it does not mean it needs to be on his body since he left it in Gauteng. In doing so, the court appears to have lost sight of the fact that this statement had been made by the co-accused counsel in cross-examination. There was no basis to attribute it to the accused. These findings by the court indicate the application of a type of reverse onus upon the accused to prove his defense, whereas as stated by the court, the accused version only had to be reasonably possibly true. Put differently, the application of the two cardinal rules by this honourable court had to exclude the accused version being reasonably possibly true. Then we say that this misapplication of the onus is further evident from the court having in its concluding remarks confirmed the two cardinal rules that require the inference sought to be drawn to be consistent with all the proof facts and to exclusion of every reasonable inference from them save the one sought to be drawn. This could never be the case in the absence of any objective corroboration that one would have expected to be present at the scene, such as damage to property, injury to people, or at the very least an expression of fear by anybody from the many people that have been in attendance at the celebration. And finally, in relation to the conviction, Your Worship, what we say is at the very least, it cannot be said that now the court might find differently or have a different assessment of all the evidence led in this trial. Consequently, it is respectfully submitted that the accused is not only a reasonable, but a good prospect of success on appeal, and this application for leave to appeal against the convictions ought to be granted. In relation to sentence, Your Worship, we submit the following. We say that the sentence imposed by this honourable court is startlingly inappropriate to the extent that it induces a sense of shock. We say further, due regard being had to the prevailing circumstance at the time of the commission of the offences.
You were just a really cock attorney. I mean, let's face it, you were super cock.
Period of time that did not exceed 1 minute.
In my opinion.
Taken as one for the purpose of sentence. There is no need or basis to impose separate sentences in respect of each charge, as this court did. We say further, insufficient regard was had to the personal circumstances of the accused. Most significantly, he's a 45-year-old first offender who was 37 years old when these offences were committed. He has not been convicted of any other offences in the interim. Additionally, he's married, he has 3 children and a wife to support. He's in full-time employment.
Well, he's got VBS money, does he not? I mean, he must stole enough money allegedly for, to look after.
Contend that he's a danger to society, thus ought to be removed from society. In this regard, Your Worship, I wish to highlight that no regard was had to the fact that he's led a blameless life during the duration of this trial, and that
Really? Blameless life, you say?
in the sentence that was imposed.
By the way, just quickly, what is happening now, thank you to Gerard for sending this. Malema's advocate is bringing, okay, I'm going to read it in Afrikaans. Aansoek vir verlof om te appeleer. Die staat gaan dit dan teenstaan. Die landdros moet dan 'n bevinding gee. Sy gaan dit teen 10-1 toestaan. En dan gaan Malema se advokaat 'n aansoek bring vir borg hangende die appel. Die staat sal dit ook opponeer. Kans is 50-50 dat die landdros dit toestaan. As sy dit goedkeur, gaan hy huis toe. As sy dit teenstaan, gaan hy vandag nog tronk toe. Woo! He might go to jail today already.
Story. The other issue, not an issue, but if you can explain.
Thanks,
I think we go
Gerard.
in a circle of a radius of 5 kilometers on each side of the court building. We're going to find about 4, 5, 6 soup kitchens. So, and this soup kitchen is specifically to the area Mr. Malema is coming from. Ms. Thompson says, correct, Your Worship. The court says, so that is, what value must the court attach to that? Because I read it is from donations. Ms. Thompson says, part of, yes. And through the facilitation of the involvement of the accused, Your Worship, so Your Worship state will continue. She says, it will continue most likely, yes. Court says, okay, so there's nothing special about the soup kitchen. Ms. Thompson says there is, then Your Worship cuts her, and Your Worship says, except that he may want to be very thankful that people are being served a meal that is outstanding. Ms. Thompson says, yes, Your Worship, and it was mentioned as part of the consideration in terms of the risk of reoffence. So the point we're making, Your Worship, is Your Worship undermined, with respect, the role that the accused makes to society. Put quite differently, Your Worship, neither, to my knowledge, does Your Worship or anybody else in this court have the right to claim that they started or initiated a soup kitchen, but Your Worship belittled that approach by saying there's so many of them, they don't need him, whereas it was he who initiated it. So I needed to make that.
I also do a soup kitchen. Can I fire firearms and then say, hey, I do soup kitchens? Tsak, man.
At the outset, Your Worship foresaw an application for leave to appeal. When Your Worship said, as to the firearm received from TSS, I dealt with this in my judgment. It will be an aspect for leave to appeal.
Like, think about that. Like, out of everything that he could have done as a leader of the EFF and as a member of parliament, the one thing he brags about is soup kitchens that everybody does. Like, well done.
Envisaged that there be an application for leave to appeal. And
Thanks,
that,
Jock Rousseau.
with respect, permeated
I'll
your
deal with
judgment
the
on
gist now.
sentence.
Thank you.
When it comes to aggravating circumstances, Your Worship, you said that Advocate Sisa had highlighted and submitted that a custodial sentence was a normal, was the right sentence because this was a deliberate and executed with precision. And once again, Your Worship said these merits will be dealt with when we reach that point. So what we submit, Your Worship, is it was always envisaged by Your Worship that there would be an application for leave to appeal, and that this sentence bears that out. Your Worship also dealt with the accused being in a position of trust. Now, when we refer to a position of trust, Your Worship, is ordinarily a person who's an employee, who looks after money or an assets on behalf of somebody else, doesn't cover the situation dealt with in this matter. And we've never ever argued that there's an absence of accountability and a breach of trust. But all of this, Your Worship, will come to the final quote that I'll address Your Worship on before I make my conclusion. And that's to the effect that Madam Justice is meant to be blind and deaf, Your Worship, and not have regard to the actual specifics of the person when sentencing in the manner that Your Worship did so here. Now, Your Worship also asked the following in your sentence. You said, the event was planned, the accused said so. I stand corrected on this aspect. It is the 5th celebration, first of its kind, and I was told that it was a well-established tradition. She said, Your Worship said, I'm unsure about this. Now, Your Worship could have clarified that. The evidence was there, but to do so in your sentence, we say is a misdirection. Your Worship went further to say it was planned.
Listen, can I just say one thing, right? You will not speak to Tanny Judge that way, all right? You get that attitude of yours, right? And bring it down a notch, okay? Whether you are disappointed or not, you will not speak to our Tanny Judge in that manner. Tone it down, or something is going to also happen in the court where you are going to be held accountable, buddy. Okay?
Quoting, nothing more, nothing less. And we say in that regard, Your Worship erred, because it's Your Worship.
No, erred. What erred?
Your Worship's questioning of Ms. Thompson.
The only thing that erred here was your weak case, bringing soup kitchens and saying the video is doctored.
You knew all along that it was dealing with the celebratory shots, and that was the instance that had been clarified throughout. It wasn't a case of being part of another offence like a murder or anything. And if one draws
well, that's why he got 5 years and not life imprisonment, right?
As well. In relation to the case quoted by my learned friend in this division, firstly, that predated the one that we referred to. So it was taken into account when the second one was a non-custodial.
I mean, does he know that she's got a Karen haircut? She doesn't care. She's got a Karen haircut with some zebra stripes in it, right? She's got a two-tone Karen. You're not going to convince her, buddy. You can try as you might. The Karen two-tone. Done.
Unlicensed firearm and somebody being handed a firearm and shooting a shot in the air, as is the conviction here. Your Worship also went into the merits of the matter.
Her future is so bright, she's even wearing sunglasses indoors. That is how bright her future is.
You would take possession of the firearm, whereas there's no evidence to this effect with respect to Your Worship. Your Worship also said that such actions cannot be condoned by the court and used to justify shots as celebratory shots. Your Worship, when we're dealing with sentence, we're not asking for condemnation. We're actually asking the court to blend the sentence or the punishment with mercy. So there's no aspect of condemnation that comes to the fore because the person's already been found guilty. So we say you erred in that regard as well. Your Worship also said that much was made of
He's yapping because this is the appeal process and she can accept it or deny it. And then also the bail application. He can still go to jail today. He can still be imprisoned. He can be out in a day, but he's still going to go to jail. He could possibly go to jail.
That was his version. This has caused a lot of consternation in this court. Even Your Worship yesterday said to my member of my team, Mr. Ngayatobi, why are you bringing AfriForum into it? And all he said was, it's in their heads, I'm quoting, and then Your Worship left it once it had been said it was the state that had raised it, but it was unfair to attack Mr. Ngayatobi in that regard. Your Worship also had regard to the financial aspect of this case on the taxpayers' pockets. With respect, Your Worship, that's a material misdirection. Could you imagine if we had to take everything into account in every trial, and with respect, it becomes something of a political speech to refer to the women who come here for maintenance can't get access to the court, the children that can't get their grants. Well, why don't we blame him for the potholes and for the weather as well, Your Worship, because they're unrelated.
Shame, buddy.
The MPA, if anybody, ought to have seen that the right resource was available. Here we sit with no aircon. Is that the accused's fault as well, Your Worship? Because the funds that were used for this trial weren't used for that. With respect, Your Worship, it's an improper approach to take, and you misdirected in that regard. It would seem that you were appealing more to the public and justifying the decision that you're going to make rather than using a legal basis to do so with respect to Your Worship. Because they're not relevant factors in relation to sentence. We cannot, on the one hand, as Your Worship did, and I've got as you say, it's your right, your constitutional right to plead not guilty. You can have a trial. Oh, but by the way, you took up all these resources, therefore I'm holding you liable. That, with respect, is not a balanced approach, Your Worship.
Okay. Well, you can wait until you're a judge and then you can do the same. Okay, buddy.
It is further borne up by Your Worship then carrying on through the time frame and saying, well, therefore the court is limited to what you're charged for and nothing more. Now, with respect to Your Worship, that implies that Your Worship wants to punish him for much more. We heard yesterday about all the different shots. We know as a fact, and Your Worship found that today there was only one shot in the charge sheet, there was one bullet in the charge sheet, there was only one ammunition, there was only one firearm. So it seems that Your Worship has misdirected.
Why does Malema have a white lawyer, by the way? I've asked this a couple of times. It's weird, right? I mean, considering how he speaks on white people, but when he's in trouble, he always calls on a white person. Go figure.
To the entire trial, and more specifically, the sentencing procedure, Your Worship.
I'll deal with all the super chats after
And
this.
then Your
Thank
Worship
you.
dealt with the
Thank you,
politics,
thank you.
and that it's not a political party that has been convicted here. It's a particular accused. But there's no need, Your Worship. If you say I'm holding you liable as the leader of the EFF, there's no need to say I'm convicting or I'm not convicting our party. It's self-explanatory.
Is that not his title? Is that not his title? Like you what idiot? Like I'm sorry.
And said that Your Worship had heard all the witnesses, and Your Worship said that politics and law don't mix. They must stay in their respective lanes. Now, Your Worship, while saying that with respect, Your Worship, and in your attempt to distance yourself from that's exactly what you, with respect, made yourself guilty of.
No.
Because your reference to the public out there, to all the people that have suffered on account of this, was more of a political speech than a judgment on sentence, with respect, Your Worship. And this, Your Worship, was also what was displayed yesterday, as I explained, in the confrontation between Mr. Ngayatobi and yourself relating to AfriForum, when it was the state who had said it referred to AfriForum. And Your Worship, another aspect that was highlighted and doesn't find any meaning is there was a debate yesterday, and even my learned friend wanted to continue further on the return of the firearm and what the correct procedure is. Your Worship, there can be no doubt, and Your Worship knows that Section 34, the court must make an order returning. The state can't decide halfway through a trial or at any juncture to return the firearm, and that ought also to have been part of Your Worship's judgment, that the rifle may be returned to its lawful owner. Your Worship identified the lawful owner in your sentence as Mr. Snyman, but Your Worship didn't go further and say, and he's now entitled to the return of his firearm because it wasn't handed by him, but it was given back to him after the event. But that wasn't.
Can I ask, why is this important? This specific thing? Why are they hammering on about the weapon being returned? Can somebody tell me?
The most distinguishing feature, Your Worship, between this Ngala Nzima case of Malundana, Your Worship, was there were victims. There was a dead child of 13 years old. There was an injured child of 13 years old. Here you have none, with respect. There the judge in a higher court still found the compassion to deal with the bereavement and the loss of life and the injuries, and still not impose a period of imprisonment on a person that had shot people, which is distinguishable on those facts, but it's far worse. And the simple fact remains, Your Worship, that to this day, the challenge was put out to my learned friend and to Your Worship to find any case dealing with what you call sugar-coated celebratory shots, we call celebratory shots, where anybody had been charged for it. And Your Worship says that's not a relevant factor. We say it is, with respect. If one can have regard to how many soup kitchens are in the neighborhood, one can have regard to how many times this actually happens in real life.
Recon says because you're allowed to use a firearm in the presence of the owner, so they're arguing that it was not in a legal possession. Well, yeah, that's weak. That's a weak argument.
Of the court's facilities and time then turned around at the end of the sentence. Each case is unique. Everybody's equal before the law, and everybody has a right to a fair trial, so we're all equal. So, Joseph, how do we find somebody more accountable on the basis that is the leader of a party, but yet we say we're all equal before the law?
But didn't you say about gangsters yesterday that the reason that he shouldn't get a direct imprisonment is because those people were gangsters and he is not? How is that fair in front of the law? Equal in front of the law? Stop talking cock.
Argument in the Constitutional Court, and ironically dealing with the EFF versus the Speaker of National Assembly, where they stated as follows, in reference to the case that did away with the death penalty, and they say, and I quote, at paragraph 235, it is after all the embodiment of the legendary Lady Justice a dispenser of justice who's blind and deaf to images of any reports on the good reputation and notoriety of personalities before her, any legitimate and relevant legal or factual points for or against any litigant. So what we're saying, Your Worship, is that justice must be dispensed without fear, favour or prejudice. It's known, it's accepted by Your Worship. That includes Lady Justice being blind and deaf, Your Worship, and not overemphasising the position that a person plays in society.
Anybody else would have received a harsher sentence. Can we be real about this? If this was the average Joe that did this, right, they would have received a 10, 15-year sentence. So I don't really know what you're arguing about.
Worship also went further to say that the accused had been dishonest in his approach to the court. And with respect, Your Worship, there was no basis for that factual finding, particularly in relation to sentence. And this, Your Worship, then impacted on Your Worship's then finding that Your Worship could have regard to corruption cases and fraud cases dealing with dishonesty. And that goes back, Your Worship, to the issue that I raised earlier of being in a position of trust. It seems that reasoning permeated Your Worship's logic or reasoning throughout this matter, and we said that that is a major, irreversible misdirection on Your Worship's part. So in conclusion, Your Worship, what we say is that taking account of the crimes of which the accused was convicted, the interests of society and the
Sorry, I was speaking to Lauren.
accused, as well as the unique facts pertaining to this matter, the custodial sentence ought not to have been imposed. The imposition of a custodial sentence is startling and inappropriate to the extent, Your Worship, that it induces a sense of shock.
Whatever is, I can't hear you when whatever is playing.
May I just listen to my colleague?
No, not at the back. There's a is it the police?
Did you hear? Did you hear? Malema's going to jail. He's lock it down. Malema's lock it down. Malema's going to jail. Yo, lock it down. He's gonna get locked down. Oh, Malema's gonna get locked down. Oh. Hey, why? Hey, this was your CIC. Hey, commander in court. Hey, lock it down. Malema, he's gonna get to prison. Oh. Thank you, my boy. Thank you.
Okay, so it's a possession of the firearm, possession of the ammunition. It's impossible without, I beg your pardon, discharge of a firearm with ammunition is impossible absent the firearm and the ammunition. Why should they be treated separately? And that's the case with Oscar Pistorius. It's common cause factor. He received his friend's firearm. He shot that firearm. He wasn't licensed to possess it. He was thinking of buying one like that. That was the justification. Yet he was only charged with discharging the firearm. Here we have the very, very similar situation. Not only, Your Worship, did the state separate the charges, Your Worship then found him guilty of all three and gave different sanctions, different punishments on each and every one of those three charges, one being a 5-year sentence, Your Worship, with respect. So if we have regards to those and we do a comparative, it cannot, with respect, be said that this appeal is doomed to predictable failure. It has a very, very strong prospect of success, as we say. So we respectfully request leave to appeal against conviction and sentence, Your Worship.
Thank you.
Advocate.
Denied. Thank you. Denied.
Advocate Caesar, I'm not sure if you already, based on what you've heard, I
Copy of them. I just want to check if Mr. Holders has got a copy of whatever arguments.
Yes, I've got a working document. It was my working document. It's not a final. I didn't do the worship, so I had just the application.
I realized that's why.
So it's my working notes.
Yes, no,
I don't ask for his notes.
No, I completely understand.
What arrogance.
That's why I'm saying, has he listened, and then does he need a few minutes to prepare a reply? Because
Yo, look at that two-tone.
I've
at that
limit. I
two-tone.
don't require. I've listened. I don't
Look at that
need
two-tone.
your working document.
Say the two-tone.
You need a few minutes.
I'd like
that
to
you could
speak
that?
to the manager, please.
Proceed.
I'd like to speak to the manager. Guilty.
Yo, that two-tone. The zebra Karen. Love it, Tanny Judge. Love it.
Understanding is correct, Your Worship. This application deals with Section 309 of the Criminal Procedure Act, where leave to appeal is applied from the Magistrates Court to a High Court. Insofar as the leave to appeal application is in respect of conviction and in the respect of the sentence. One of the factors that has been mentioned, if my memory serves me correct, and counsel can point out to me whether it is inaccurate, that Your Worship failed to take into consideration that the principles in Rex versus Blom relating to the only inferences relating to the incident in question, that the accused did in fact possess the firearm and that he did in fact fire those shots. Yes, please, our submission in that regard, the court took into consideration all the evidence, including the video evidence, which the court deemed to be admissible. And like I've already said previously, that it was enough evidence for the court to come to that particular shots, and that there are no prospects of success relating to the conviction and sentence in this regard. If we deal with applications for leave to appeal,
Hey, wat kyk jy?
I've heard counsel say there are good
Moenie vir my
prospects,
so kyk, jou
but
krimineel.
it's not the only requirement. The
Ja,
mere
kyk weg.
possibility that another court might come to a different conclusion is not enough to convince the trial court to grant leave to appeal. The reason for that, why the courts have taken such a view, if Your Worship is of the view that the conviction was correct, allowing an application for leave to appeal will absolutely amount to a waste of judicial resources when there's no prospects of success.
Yes.
I submit that counsel might have an arguable case, but there's no realistic chance insofar as the conviction is concerned that he will succeed. It has been pointed out in so many cases, the Supreme Court of Appeal has stated what is the test of reasonable prospects of success, postulates it's a dispassionate decision based on the facts and the law, that the Court of Appeal could reasonably arrive at a conclusion different to that of the trial court. In order to succeed, therefore, the appellant must convince the court on proper grounds that he has prospects of success on appeal, and that those prospects are not remote but have a realistic chance of succeeding, most required to establish than that of a mere possibility of success. A mere possibility of success, an arguable case, like I said, or one that is not hopeless is not enough. This is basically what I said counsel have argued before, Your Worship. There must be a sound, rational basis to conclude that there's a reasonable prospects of success.
Reaper Man says we are here to hear the case, not your dog. Well, then go and watch it on the SABC. There's no dogs there. Go and watch it on the SABC. Stop being so entitled. Don't tell me what to do on my channel, buddy.
Exactly with every issue that has now been raised by counsel, whereas the court have
It's like me walking into your house and then just going to take a poo and not flushing and then lecturing you on why your place smells funny. Huh?
prospects of success and no realistic chance that it will be overturned on appeal. And so far as the sentence is concerned, Your Worship is of the view that I did request that the 15-year sentence must be imposed. I also provided alternative sentences which might be imposed to the accused. I'm satisfied with the sentence that was imposed by this court. As a matter of fact, I find it to be fair and regarding to the facts of this case, there's also no prospects of success relating to this particular sentence, that a different court will
Yes,
come
maar daai
to a
hare
different
is
conclusion, and that the court should dismiss this application. The issue with bail, I will deal with your worship as we go along, depending on the court's finding whether there are indeed prospects of success or not.
Daai hare, daai feit is ingemoer. Soos Ries altyd sê, daai feit is mooi ingebliksem. Na.
Start with the
Hey,
arguments
hey,
made,
hey. Go to jail.
about the correct test. It seems that my learned friend wishes us to argue that your worship is wrong, but we don't have to argue that you are wrong. It is on appeal that we will argue that you are wrong. What we are dealing with today,
Like, who looks at those glasses and go, damn, I need that pair of glasses? Like, what?
the court might come to a different conclusion. In other words, is there a realistic prospect that that will be the case? Both on the questions of fact and on the questions of law. So it's crucial to underscore that test. And the exercise is also not a repetition of the case that your ladyship has had. Your ladyship is now functus officio in relation to your judgment. So we don't have to persuade your ladyship that you were wrong. We simply have to show that someone else looking at the same facts might come realistically to a different conclusion. The only argument made by the state, and it's important to examine their case, what they have said now, is around R versus Blow. That's the only thing they have said. Now, your ladyship, if you contrast that with the
Kenny.
case that has been made on behalf of the accused, R versus Blom is one aspect, but there are so many other grounds for leave to appeal that have been advanced. The reality, your worship, is that none of those have been responded to. What you have is just a generic submission.
That's
that
my
there
other
is no
doggy,
reasonable
Kenny.
prospect of success, and there is no reasonable likelihood that a different court looking at the different facts might arrive at a different conclusion.
No.
So in effect, you are then not dealing
Isn't this the advocate that constantly loses cases left, right, and center?
the state. They've raised only one ground and they've ignored each and every ground, and they've put them under this omnibus category that there is no reasonable prospect. So that's point number one, that actually this is not meaningfully opposed by the state. Point number two is that what that does is that it therefore leaves those grounds uncontested. Now, that has serious implications then for your worship's weighing an assessment. So if you have an accused person that gives you 10 grounds, and you've got the NPA that responds to one ground, and that leaves 9 grounds unopposed in effect, what does that then do to the court? Is the court now supposed to fill the gap left by the state? I'll tell you why they've taken that approach. It's because they themselves accept that this is a strong application for leave to appeal on fact and on law. So if that is the case, then that's the only logical deduction to be drawn from the unserious opposition, is that actually this is a cogent application for leave to appeal. Then it leaves your ladyship's road very easy, because you don't have to decide whether you are right or whether you were wrong. Someone else must decide that. The job is very easy. The High Court must make a fresh evaluation of the evidence and make a determination whether the convictions were safe or not. That then takes me to the question of sentence. We have a similar approach taken by the state. This is what they said. I noted it down. they say, we've asked for 15 years, we've got 5 years in one and 2 years in the other. We are very happy with that. Of course they are. But the question is whether there is a realistic chance that someone else looking at these facts might arrive at a different conclusion, or whether or not there is a reasonable likelihood of success on the appeal against sentence. If I have to weigh, and I'm not doing that weighing now, the two appeals, the conviction and the sentence appeals, I would say the sentence appeal enjoys the most excellent prospects of success. One, because you are not dealing with a field that is occupied by judicial precedent. And it is correct as a matter of law, if you are not dealing with a field that is occupied by consistent precedent, to say the higher court must relook at it. And that is not because your worship is admitting that you were wrong. Your worship is simply saying there are different views in this field of law, and let the higher court relook at this and make a determination. Just take one example on the discharge alone. Look at the 4 cases we looked at yesterday, if you remember all of them, Your Worship. You know, none of them resulted in direct incarceration, none, 0.
But this one did.
And you look at the case presented by the state, they are unable to point to a single case of a discharge that results in direct imprisonment, or discharge alone. Then you look at your ladyship's finding, count 2, which is the discharge count. You've sent Mr. Malema to 2 years direct imprisonment. Now, can you be confident that there is no other court that realistically may come to a different conclusion? I think that if you took that view, your leadership will probably fall into an error.
Whatever. If you are happy that Julius Malema has been sentenced to 5 years imprisonment, smash the like button, subscribe to this channel, and consider becoming a member to this channel if you want more of this content. And also maybe gooi a super chat. You guys have been blessing me like crazy today. It's greatly appreciated. Thank you very much.
So even that, in a position of 5 years, is not a safe direct incarceration, no option of a fine, no suspension. Not necessarily a safe.
The reason it's 5 years and then an additional 2 years, they run concurrently. So it's 5 years. It's not 7 years because it's not separate. It's 5 years because it's a 5-year sentence and a 2-year sentence, and it runs concurrently.
I'm not going to complain about the declaration that Mr. Malema is not fit to possess a firearm, because it follows from the convictions. If those convictions stand, then there's no problem with that. But if those convictions, there's a realistic chance of setting them aside, then as a matter of logic, the balance follows. So what am I saying then on sentence? I'm saying to your leadership that it is possible that someone else, realistically possible, that someone else will say this sentence induces a sense of shock. Now we can say that, my lady, without fighting with your leadership about who introduced politics in court. We can say that purely on judicial precedent. And we can say that purely on application of legal principles. And when your leadership considers this, your leadership, we accept, will be dispassionate. And your leadership will be blind to the politicians sitting behind me, and will be looking at the accused without identity. And then decide, well, does he deserve to have his case re-evaluated by a higher court or not? Now, if your leadership even refused that, then we will say that your leadership is not acting in accordance with the oath of office. But we trust your leadership that you will act in accordance with the judicial oath of office and send the matter to the High Court, let them re-evaluate it. They might agree with your leadership, but there have been many instances before that you think you are right. I've been there myself. I think I'm right, and then 5 judges sitting in the Supreme Court of Appeal say, sorry, acting judge, you were wrong. And that's where we are today. Your leadership may be overturned. And so we ask, therefore, with respect, this is a discretionary matter, but at the same time, it is a matter of application of settled legal rules. So we would therefore ask that you send the conviction, you send like
no.
I just respond to political speech.
Since I've heard what you've said, Advocate Otis, and thereafter Advocate Mkaitobi and Advocate Sisa, it's not a difficult issue as you've stated. The law is clear. I'm going to extract the relevant parts and return, can we say 12:30? It will give me sufficient time. Please, just a minute, just a minute. Okay, thank you. Court will adjourn.
Yay! Yo. Where is it now? I'm looking. For something special. I'm looking for something special. And now I can't find it. Murphy's Law. Murphy's Law, right? Yes, Murphy's Law. Well, what am I looking for? I am looking for okay, is this ever gonna happen? I'm looking what am I looking for? Oh.
Correct, because the sentencing with the 5 charges to be separate. That was among their pleadings. They had wanted for him to get one sentence and not each charge coming with its own sentence.
Games. Klein man Malema. Little man Malema. Bedorven brat met rooibaret. Yes, you with the red beret. Lieve uitspraak elke dag. Hate speech every day. Allemaal wat nie saamstem nie. Anybody who disagree, you chase away. Jy skree en skel, you shout and scream. Call names, want allemaal moet luister. Maar niemand hou van jou nie. Ja, nobody likes you. Jy so alleen, sad little man. Hey, jy love die mic, love die drama. Love to spread the fire. Hate everybody who don't clap when you say revolution high of it. Swart in die color. As hulle nie klap nie, then they're the enemy. Maar as die hof...
Well done, Tanny Judge. Well done, well done, well done. Let me see if I can get somebody on here quick. Let me ask Adams if he can come on. Let me also just do this quick. Let me just catch up with the super chats. Thank you very much for all the super chats. It's greatly appreciated. I mean, you guys are truly going above and beyond. Absolutely insane. So don't go anywhere because at the moment, the appeal, she could still deny bail, which means that he'll be in cuffs pretty relatively soon. So don't go anywhere, everybody. All right. Let me see what I've read here. I just quickly want to run through this. Okay, Fred just joined. What was the outcome? Okay, a bit late. 14 years. 14 years. 14 Rand super chat. He got 5 years. Fred, thank you. Juju just okay. I did. Hellwolf, thanks for the 14 Rand, saying effing finally. Fatum Fluffy, thank you. Timo Ryan, thanks for the 14 Rand. Regs, thanks for the £10, saying South African in the UK. Loving the channel. Well, thank you. I appreciate it. And thank you for your £10. You just covered my home mortgage for the next, 10 years. Jason East, thanks for the 20 Australian dollars. Brand, thanks for the 10 Rand. Jock Rousseau, thanks for the 350 Rand super chat. That was also your very first super chat on this channel. Thank you, Jock Rousseau. Greatly appreciate that. Lily Tongley, thanks for becoming a member. Louise Haroff, thanks for the 14 Rand. How ironic that he has a white lawyer. Go figure. Thank you. Vanessa Blossom, thanks for the 35 Rand, saying please give the judge protection someone. She already has, I can guarantee you. Carl Brown, thanks for becoming a member. Pissed Off, gave a 14 Rand, saying sing Carter, they are boring. Thank you. Charlotte Sneyman, thanks for the 25 Rand, saying thank you for all the work you do. Well, thank you for supporting me. Can't do it without you. Thanks to Matthew Cohen Power Pod for 35 Rand. Also, please be sure to go and subscribe to Matthew Cohen Power Pod. Please post the link, Matthew. Another phenomenal South African content creator that can do with support. So please go and support. He produces amazing content. He says, fun afterthought. What will happen to the EFF even if he somehow evades prison? Malema's political career is done. Well, the EFF's going to collapse in on itself because now the hyenas are coming out and they're going to slaughter each other for that position, and people are going to leave the EFF now. Mercuriaz Leo, thanks for renewing your membership. Hannes Olivier, thanks for the 14 Rand, saying make doggy wave, bye-bye, go to jail, Julius. Prrpa. Thank you. Jacob, thanks for the 140 Rand, saying nou net wakker geword. Weet nie waaroor ek die opgewonde my morning glory of die 51 op Juju se tronkstraf. Oh, as jy excited is dat jy 'n morning glory het, dan is daar 'n probleem, ou bil. Jy moet gaan piepie. Beret Jory, thanks for the 100 rand, saying throwing in some bucks for that next haircut. Appreciate you, man. Been a fan since way back in 2012. Well, thank you, Beret. I appreciate it. Okay, so let me just get this ready because Adams has said that he can come on. So I just want to create the link. Let me just create this link quickly. And then, yeah, okay, so this is ready. Let me just send the link out. Let me send the link. By the way, we're not done yet because he could still go to, he can still be in prison today. Okay, I'm just waiting for them to accept it. And then we're going to talk about this very quickly. Be sure to smash that like button, everybody, please. Consider subscribing to this channel if you have not done so yet. And gooi a super chat or become a member if you're supporting what is happening here. Okay, let me just do this. Give me a second, please. I see Rob is already here. I'm just muting. I'm muting this. Okay, and jeez, I'm running a proper show over here, but just not with SABC money. Okay, so Rob, how's it? Let me just move this over here. There we go. And then is that right? No, there we go.
How's it doing, hello?
How's it to Rob and how's it to Adams van Sail, not Adams Roots because I always get it wrong. How's it going? So guys, I mean, listen, I did call this a couple of months ago already. I did say between 3 to 5 years and look at that. So let's start, I suppose, with Adams because AfriForum was a critical part in this court case actually being taken up by the NPA. So how are you guys feeling over at the AfriForum headquarters?
Yeah, well, Ronaldo, I think the main point is that today is a big win for equality before the law. It's a big win for AfriForum. It's a big win for the law-abiding citizens of South Africa. It's a big win for all of those citizens who, if they were in this position that Malema was in, they would have definitely gotten sent to prison. For them, it's a win because they know that at least he has one politician that's not getting the special treatment that he demanded. His supporters were screaming all day yesterday and this morning about Julius Malema being a special type of person. He's a special part of a special class, you know, that don't deserve to be held accountable. They should be allowed to commit as many crimes as they want to because they're just so special. They're not like you and me. That was literally the EFF line for the past 48 hours, making the argument that politicians should be above the law. If you sit in parliament, it shields you from any type of criminal conviction against you. But now that whole strategy seems to have blown up in their faces because on the one side, they weren't successful in pressuring and intimidating the court to not send Julius Malema to prison. They've also now exposed themselves for the how many time as a political party that is pro-criminality and pro-lawlessness. And lawlessness and criminality lost today. Correctly, you did point out, I do appreciate all the love that I'm seeing towards AfriForum today. If you're not a member, become a member today to show your support for AfriForum because it was AfriForum that laid the criminal charges against Julius Malema all the way back in 2018. And it was AfriForum's private prosecution unit under the leadership of Harry Nell that had to threaten legal action to force the NPA to make the decision to prosecute, which they eventually then did. So major role that AfriForum played in this win. And yeah, I'm very glad to see all the support out there. Even the EFF are helping us by reminding everyone what organization keeps the politicians of South Africa accountable, even the criminal ones. by holding up signs which Futsek AfriForum, they're just reminding everyone out there, the entire country, which organization is making sure politicians are not above the law. So thank you, EFF supporters as well.
Well, there we go. I mean, that is absolutely fantastic. And listen, I know that you are busy, so if you have to jump off the call, then just leave. You know, you don't, I mean, I understand that there's probably a lot of media houses that's reaching out to you.
I'll let you know.
Rob, how are you feeling, buddy? And what is the business sentiment? What are your friends, your fellow wealthy business owners and everybody saying about this?
Well, as you know, the fellow wealthy business owners tend to say everything around the braai, but nothing out in public. But, you know, if I hadn't been trapped in my computer working and then listening to Ronaldo, your magnificent show, I would have run outside and shouted, yes, 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 Juju, go to jail. I mean, I was over the moon. My wife was like, fantastic. This is great news. What about Cyril and the Guptas and all the other boys and Zuma? And she's right. You know, today is a big win for AfriForum. I salute AfriForum. I'm a member. I send them money. Everybody should do the same. They are an extraordinary organization, and they're keeping South Africa honest. I mean, well done, AfriForum. Well done, Gerinel. Well done, Ernst and the gang. Salute. And it's a win for South Africa. It's a win for the decent people of South Africa. It's for our judicial system. Even the NPA, having been forced into this, has done the right thing. You know, it's not nice that they had to be, you know, clapped along the way to get to do their job, but the job was done. And well done, that judge, for not buckling. Look, there's going to be an appeal. It'll still be a little while before the just sentence is put in place. But I think Julius is going to jail. And no matter what those idiots in red berets do, jumping around the courthouse, threatening people, he's going in. He's in an orange jumpsuit, and Cyril should follow. You know, why isn't Cyril in the dock for Pala Pala? I mean, anyone else in that situation would be in trouble. So this is a great day for us all South Africans. It's a great day. And well done. Great coverage there. I loved your coverage, Ronaldo. I was laughing all the way, listening with one ear and working on a conference call on the other.
And I see Jock is also there on the ground at the court case. But Ronaldo, you pretty much created the meme of Tani Judge that I think people are going to be referencing for quite a while.
Well, there we go. I mean, I love that she did her hair like very Karen-esque and then put the zebra stripes in it just to say, hey, I'm here. So, yeah, I mean, I think it's a great day for South Africa, like Rob said, and also AfriForum just once again showing their weight around, you know, holding people accountable and that nobody's above the law. I would like to get your gentleman's take, though, on whether or not, because they're dealing with this appeal process right now. And then I'm also assuming that right after that, they will discuss bail, because there is a possibility that Julius Malema will be, imprisoned right now, pending whether the bail application is successful. So what are your takes on that? And also, what do you think? I know it's two different questions, but what do you think of whether or not he will see a jail cell today? And secondly, what do you think will happen to the EFF now? So let's start with Aaron.
Well, from my side, I'm just glad with this win. I'm not going to go too deep into the details. I'm not a legal expert, and I really don't want to send people down the wrong path, either pessimism or positivity. That's false. So I think in regards to your question, I don't really have any insider details on what to expect next. But it's a major win for accountability, and I'll take it.
Great. Rob?
Well, we need prediction markets in South Africa. So if you guys follow Poly Markets and Kalshi, we need a South African version, which I'm working on right now with Nick French. But that would tell us what the likelihood is. I don't think he's going to be put in jail. I think he will be given bail. I just think, you know, she's been very accurate. She's given the right judgment. She's been tough. And I think on balance, she'll probably, if she's going to do a little give, it'll be to not throw him in the chookie today and to give him bail and to allow that appeal process to go through. So that's my instinct. I just think that will be, if any give, that will be the give. Otherwise, a superb job has been done. But wouldn't it be nice to have him led in handcuffs into Chucky today? Wouldn't that be nice?
Yeah, I think it's after years of seeing things that he's done and said, and then being able to wiggle his way out of it. I mean, the Kill the Boer song is one example. Another one is like asking, saying that he's not calling for the slaughtering of white people, at least for now. And I mean, a lot of people will now see this as a black versus white issue, but it's not. This is just about, being equal under the law and allowing justice to just go according to what it should, and not receiving preferential treatment because you are somebody of a political party that will cause havoc. Let me ask you though, do you guys think...
You asked us about the future of the EFF as a result.
Yeah.
If he does go to jail. I think the EFF anyway had a glass ceiling at around 8% of the vote, around there. They were never going to get more than that. Prince Mashele and Frans Cronje, both very smart political analysts, have agreed with that, have said the EFF is, a personality cult of Julius Malema, as is MK with Jacob Zuma. What happens when those two leaders leave? The reality is MK is a revolving door. You get, idiot after idiot joining, and then the family can't handle them, and they flick out the other side, and then they look for another home to join. The EFF has lost a lot of its top guys. I think top's a bit of a misnomer for them. Have lost, Moron 2, 3, and 4, many of whom went to the MK. And, with Julius going to jail, he's going to be seen as a loser, going to be seen as a criminal. And the majority of South Africans look at the EFF as troublemakers, dangerous, and bad news. And other than some radicalized students at UCT and University of Joburg who vote EFF, and completely impoverished people in Mpumalanga and up north, the EFF has no future. And without Julius, I don't think he'll become a martyr in jail. I think the EFF will slide into obscurity, which would be a good thing.
Yeah. Added to that, I mean, do you think that there'll be riots? Do you think there'll be some things that are taking place? I mean, have you guys heard anything yet from AfriForum, the neighborhood watchers?
I don't think. I think there are going to be protests outside the court, and there'll be protests when he's led to jail, and there'll be protests outside the jail. But, I mean, how many people will it be? 50 people? They lose interest after a while,
Adams?
Yeah, it really makes, if there is rioting and looting and criminality from the EFF in response to this, pretty much just strengthens my point from earlier that the EFF is the crime party. It is the party of pro-lawlessness, pro-criminality. It is the party of chaos and destruction. And what is their response then if they are going to now burn things and destroy things and steal things because their leader is a convicted criminal, and rightly so? Well, that just proves and cements once again that they are the party of criminality and the party of lawlessness. And I think South Africans are just sick and tired of criminality and lawlessness. So I think a lot of people, black and white, all different backgrounds, are happy to see some accountability.
Can I make one amusing comment? When Gayton McKenzie and Julius Malema go at each other in Parliament and in the press, one calls the other a cockroach and the other calls the other a gangster and a jailbird. Well, guess what? Julius might be struggling to throw that epithet around.
Well, I mean, he is a convicted criminal. I mean, when he was found guilty, he is at the moment a convicted criminal. And I think the judge, or the magistrate, technically, I mean, I call her Tunny Judge, but she is a magistrate. I think that she firstly did a phenomenal job at covering this court case, crossing the T's and dotting the I's and getting everything according to plan so that the appeal process will be unlikely. And I don't want to hammer too much on the appeal process, but just to also give context here, yes, he has been given a 5-year prison sentence, but that doesn't mean that he automatically loses his seat in Parliament right now. This is all pending the success of whether the appeal will be heard, and then I'm assuming that Parliament will wait to find out whether or not his appeals are successful. But as it stands right now, he hasn't lost his seat in Parliament yet. What do you guys make of that, though? Do you think that, how do you think Parliament will respond to this? Anyone can go.
You can go ahead, Rob.
Parliament, I think we'll just gloss
over
other
political parties, to be more specific. Sorry.
Oh, no, I think they'll applaud it. I think most political parties will applaud justice being served and a due process being, adhered to. We always hear about state institutions being captured, and I have a suspicion that our judiciary is about 50% captured, and 30% people that are just completely incompetent. So if you are innocent and you get the 20% remaining, you've got a chance. But, you know, if you've got a highly politicized court case and the 50% captured judges are one of your judges, you know, the trial's going to go in the wrong direction. So I think this is justice served and well done. Great result. In a funny way, I think the ANC will support it. They won't say anything, but they'll actually be thrilled because it sends a message internationally that you know, the bad guys do get their comeuppance in South Africa eventually. Even though not enough have, it'll be a very positive message for the world. You know, people will heads and go, yeah, he's the kill the Boer guy, and he's going to jail, and whatever he's going to jail for, he deserves it.
And from now on, or it's been this case for a while, but whenever you talk about Julius Malema, you can always preface it with convicted criminal Julius Malema, and it's 100% true.
Yeah. And I'm assuming that we're all probably waiting for Elon Musk to post something out with regards to this, because we know that he's been hammering the EFF and specifically Julius Malema. So I think this also, you know, just for the international community makes the EFF look even worse, because now their leader has been convicted of a crime and he is sentenced to jail. So this also causes a lot of credibility loss for the EFF and specifically for Julius Malema. With regards to the judge or the magistrate, how much pressure do you think that she was on during this case? And I mean, perhaps let's start with Adams. Did you guys hear anything of intimidation, or, you know, we know that they tried to do that with the amount of people outside, but was there any death threats? Was there anything that you guys heard of?
You'll have to ask Jock. He was much closer to the case in that regard. I don't know of anything specifically, but as I said, I'm only Jock's backup. I'm the B team when he's busy. I mean, he probably has now 20 or 50 interviews lined up for the rest of the day. But Ronaldo, before we continue, I just want to share something with the audience as well, because I saw a handful of people saying, "Oh, well, this is a cruel punishment. This is it's happening to a good guy. Julius Malema is a good man." But I want to share my personal experience. I don't know Julius Malema personally, but I have sat in the same room as him during the Kill the Boer court case in 2022 when he was testifying. And I was sitting there in court and I was listening to an old farmer break down in tears on the stand as he told the story of losing his wife in a farm attack. And that farm attack left that farmer paralyzed. And he testified how the chant "Kill the Boer" causes him immense trauma. And Julius Malema was there in court. And then Advocate Oppenheimer, who you've had on the show, who was part of that court case, he asks Julius Malema the following. And when I heard this unhinged response from Julius Malema, I realized I was in the presence of real evil. So Advocate Oppenheimer asks Malema whether he would stop singing the song if he saw there was risk that singing "Kill the Boer" would lead to people killing others. Malema answers, no, he will not stop singing. Oppenheimer then tells Malema, and this is Oppenheimer's words, "The complainant has laid evidence of someone whose wife was murdered in front of him who is now paralyzed. He testified in this court. He said that whenever he hears the Kill the Boer song, it brings back the memory of that day. He broke down into tears in this court. That is trauma. That is legitimate trauma. Does that evidence motivate you, Malema, to stop singing the Kill the Boer song?" And Julius Malema looks Advocate Oppenheimer straight in the eye and he says, no. Oppenheimer asks him again, so that individual case did not move you? The case of the farmer telling about how he was traumatized and the murder of his wife and how he was paralyzed. And Malema responds, no, I'm not moved. And then Oppenheimer asks Malema again about the legitimate pain and trauma that farm attack survivors have to endure. And Malema's response next is truly like psychotic and unhinged. He just starts screaming. He just says, I said I'm not moved. I said I'm not moved. I will repeat it 5 times. I'm not moved by the case you brought me here. I'm not moved. And if that will make me lose this court case, let me lose it. I am not moved. And I'm sitting there and I'm just thinking that this is a genuine evil guy. This is not some gray case of, well, one man's freedom fighters, another man's terrorist. Like, no, this is a genuinely bad guy that holds genuine resentment and hatred, and someone who feels absolutely nothing for the murdering of farmers. He feels nothing for the stories of farmers that have survived horrific attacks. When he hears those stories, he goes out of his way to proclaim, to shout to the world, I do not care. I am not moved by these stories. So, I'm not responding to a large amount of people, but I wanted to put that on the table as well. For the handful of people who say, this is cruel, this is he's a good man being targeted. I'm like, no, this is a genuinely evil person.
Yeah, thanks for that. I think that also provides a lot of perspective. I see that Rob jumped off. Oh, welcome back. I thought you were being,
I just want to, I do have to jump off, and I just want to say this is a great day. The EFF is a nasty, evil, racist organization. Those are racists. And Julius Malema is the chief racist and chief purveyor of evil. And the fact he got sentenced to jail, it's a wonderful thing. Well done, South Africa. Bye-bye, Juju.
And before you go, I expect a video before the end of the day from Truth Report with Rob giving his analysis on this, please. Thank you, Rob.
Cheers, guys.
Have a good
Bye,
one.
Ronaldo.
Cheers. Before we go, because it's going to, and what you said, Adams, is actually so true, because everything that Julius Malema has done is for his own benefit. And then he's now got he's got a cult following of people. I mean, today you saw, and yesterday, and every time they've had this court appearance, there are thousands of people during a normal, regular working day standing there or were bussed in. They don't have jobs. The EFF is maybe providing them 2 or 3 meals a day while they're there. But like, I don't understand how somebody like him that has actually shown no interest for the poorest of the poor manages to get this amount of support.
Yeah, well, there's a lot of sick people out there, unfortunately. But yeah, Ronaldo, I've got to run there. I've got a lot of stuff to help Jock with as well. Just want to say thank you very much for everyone's words of support and all the support for AfriForum as well. If you're not a member yet, become a member today. Thanks for the big shout out, Ronaldo. I think we're definitely going to get some new members after you say that on the stream as well.
Spam the comment section, please, again. And thank you to AfriForum for leading the charge and holding people accountable in this country. Without AfriForum, this would not have been possible. We would not have seen this day. So thank you very much. And yeah, good luck. And hopefully,
I also just want to point out my prediction was correct. I predicted that the sentence was going to drop when you get 10,000 people watching the stream. I think the judge was just watching for that 10,000 number. And then when it hit 10,000, then the sentence dropped. So
no, she had, on her phone, she had the live stream, and then she went, okay, now let's do it. But thank you, Adams, and thank you for the great work that you guys are doing. Keep it up. Appreciate you guys. Cheers, bud.
Cheers. Have a good one.
You too. All right, everybody. We are going to go back momentarily when when the court is back in session. But once again, I mean, why not? Why not? Why not?
Morgen gaan jy tronk toe, Boeta!
Nee, vandaag.
Klein man wat groot wil speel.
Wat doen jy?
A little man want to play big games. Klein man Malema. Little man Malema. Bedorven brat met rooibaret. Yes, you with the red beret. Lieve uitspraak elke dag. Hate speech every day. Maar wat niet saamstem nie. Anybody who disagree, you chase away. Jy skree en skel, you shout and scream. Call names, want allemaal moet luister. Maar niemand wil van jou nie. Ja, nobody likes you. Jy so alleen, sad little man. Hey, you love your mic, love your drama. Love to spread the fire. Hate everybody who don't clap when you say revolution, high of it. Zwart in die color. As hulle nie klap nie, then they're the enemy. Maar as die hof bel, when the court calls, dan huil jy, they're picking on me. Bedorwe klein vriendkie, ja, spoiled little boy. Gooi tantrums op die verhoog, rooi oorpak, red overalls, groot stem, big voice, maar binnen is jy net rage en haat om geld te maak. Jy wil die grond hee, you want the land, jy wil die mag hee, you want the power free, maar echte leiers, boy, you hear me, real leaders build, you only know how to.
There we go, I like it, lekker. Ek is nou beter by. There we go. I posted the link to the song there. I've spammed the chat. All right. We should be back momentarily. Let's just check what's going on over here. No, the judge is not there yet. So we are waiting to see whether appeal will be granted for a higher court, and then also the bail application that will be heard. So there's still a couple of things that need to happen right now. So we are waiting to hear that. I need to just deal with some of the super chats that has been coming in. You guys are truly blessing me today, so thank you for that. It's greatly appreciated. Jakalstsak gave a 14 rand saying brr, pa, pa, pa. There we go. Alom van Jik. Wow. How do you say that? Alom van Dijk. Welcome to the Voortsakkers. I need to learn how to say that name and surname. Aloma. Oh, okay. It's Aloma. Aloma van Dijk. Adam Piercy, thanks for the 14 rand. Say, do you think he will get a blue-collar prison cell? I don't care what cell he gets. As long as he is in a cell, I'm happy. The Donex says, CIC, clown in chains. I like that. Thank you for the super chat. Mark Bracco gave a 40 rand super chat. Thank you. And then Can't Decide on Name. Love the name. Gave a 35 rand super chat saying on SABC yesterday, one of the top EFF members, a female, accused AfriForum of burning vehicles. Any possible response from AfriForum on this? Yeah, they're talking about that court case that happened, I think, a couple of years ago, and it wasn't AfriForum members, it was community members. But as is always the case, they just blatantly lie, and they don't care about the truth. But let's have a look at this.
Are here. It's a huge sense of disappointment from them in terms of the outcome of this particular matter at the moment. And in actual fact, I think many of them are saying they're disappointed with what the outcome has been at the...
Guess what? We don't care. The law was implemented today. Just because your favorite now finally was found guilty, sorry for you. He broke the law. He faced the consequences. That's it. Just because you like the guy doesn't mean that he can just go and break the law. All right?
In EFF members who have gone out in their numbers. They've been waiting in anticipation for today's sentencing. But of course, they're saying it's not over. And as you can see, of course, the lawyers representing Mr. Julius Malema are going a step forward. In fact, we knew this a couple of months.
By the way, why does this guy have a golf stick over here? Like, what is he playing golf? What's going on with this golf stick over here? And then the knopkiri over there. What are you guys planning? Huh? It's going to end badly for you. I promise you it's going to end very, very badly. Ask the people in KZN what happens when you mess with the community. That's all I'll say.
Most of the speakers, of course, are KuGompo, but obviously this is a very disappointing result out of KuGompo for the EFF, for its leader, Julius Malema.
Well, look, it's expected. The commander-in-chief always knew that leading a revolution, it's either they are going to kill him or they are going to arrest him. And but one thing is certain and for sure is that economic freedom in our lifetime will be realized. So we're at least anticipating this, because this is a line of march from Donald Trump, who made it very clear that the commander-in-chief must be arrested. So this is a follow.
What does Donald Trump have to do with this? Like, he shot a gun himself and was recorded. Blame the EFF member that recorded that, because that was the evidence that put him in jail.
In charge of the lives of the commander-in-chief. So in essence, there is a process that's unfolding. We are appealing and asking for the right to appeal at any single level that might arise. But having looked at the conduct of the magistrate, one can just draw conclusion to the fact that she might just not grant it, but we are ready. And we must also note as a society that the right to appeal at this level is a direct respect of the structures that are there, particularly in terms of the judiciary, and an appreciation that the EFF is fully respecting that.
Thanks for the super chat, Johnny Water Bergster. 40 Rand saying, great channel, Ronaldo. Appreciate you. And then Bronx X gave a 200 Rand saying, Kim Hiller is having a mental breakdown on X. Lekker man. Well, yeah, I mean, at least now she can write another book on black pain and profit off of this, because that's all Kim Hiller does. She writes books on black pain and then she keeps all the money. Make it make sense, right? Oh, but she's a Khaleesi. She's like one of those Khaleesi's, you know, when the people of color lift this white person up and carry her on their hands. This is what Kim Hiller thinks she is. Thanks for the 200 Rand. Appreciate it. By the way, we are 80 subscribers away from 219,000 subscribers. So can I please ask the 6,600 people here that if there are some of you that have not subscribed, please do the right thing. Please subscribe to this channel. It'll be greatly appreciated. Let's get over that 219,000 mark, you know. Hoekom nou nie? Dis so 'n lekker dag vandag, you know, why not? Why not? Blood Rain. Oh, I love that game, by the way. Blood Rain. Gave 140 Rand super chat saying, do you have a link for the Malema song? Thanks for all your work. Yes, no problem. And thank you for the super chat. There, I've spammed the chat with it, so you can go and find it over there. By the way, thanks to the moderators for doing an absolutely brilliant job on this channel. And please be sure to smash that like button, everybody. And like I asked, please be sure to subscribe. Let's see if my request worked there. Oh, now we are 40 away. So it kind of worked. So if you can please subscribe right now, you can just press the subscribe button over there somewhere. That'll be greatly appreciated. Thank you. JJ Henning gave a 14 Rand saying, I just joined again. Any update? Yeah, Julius Malema has been let off the hook. He is not guilty on all charges. The judge also said that the taxpayers will compensate him with 5 million Rand to apologize. It's really unfortunate, but I'm talking Kaki got 5 years direct imprisonment and just an additional 2 years that will run concurrently. But let's listen to what she has to say, because she looks happy.
For this leave to appeal, we've heard from the EFF leadership as well as the legal teams that they're going to be taking it as far as they can to the highest court in the land. This is the constitutional court of the country. That would be the highest arbiter, of course. But what is quite clear is that this matter...
Okay, I can't hear you. Gerrit Milan gave a 20 Rand saying Malema got 7 years prison in total. He got 5 years and 2 years, but it runs concurrently, so it's technically 5 years. That is what he got.
But let's take you back to the city of KuGompo. Magistrate Toinette Olifiel now on her seat. Let's listen in.
Okay. I'll proceed now. Just a few. So I just need to solve a few minutes. Take 1 second.
Thanks, Adam PSC, for the 35 Rand super chat saying, so it's Thursday and they're all sitting there unemployed, shame man, tough life. Would love to ask him to spell EFF and see how many can do it. Thank you, and thank you, Wimpers, for becoming a member. It's greatly appreciated.
Sentence in this matter. Firstly then, for record purposes, the court needs to be particular. The matter is before court in terms of section 309 capital B of Act 51 of 1977. Therefore, leave to appeal in respect of conviction and sentence. The said judgment was handed down was it 1 October 2025, and sentence imposed today, 16 April 2026. The defense being Advocate Hodes SC and Advocate Kaitobi SC had immediately after sentence indicated the intention to seek leave to appeal conviction and sentence. I will deal with two case laws that specifically is used daily by our courts dealing with matters of this nature. And I will refer to State v. Mabena and another, 2007, 1 SACR 483, Supreme Court of Appeal decision. The following was noted. It is the right of every litigant against whom an appealable order has been made to seek leave to appeal against the said order, Such an application should not be approached as if it is an impertinent challenge to the presiding officer concerned to justify his or her decision. A court from whom leave to appeal is sought is called upon merely to reflect dispassionately upon its finding after hearing arguments and decide whether there is a reasonable prospect that a higher court may disagree. In this regard, the only comment the court will make is with regards to one aspect as highlighted by Advocate Hodes, and that is that the court had anticipated the appeal. On that, I would say it is the duty of every trial court who imposes an appealable or hands down an appealable judgment or sentence to at all times be aware you've handed down an appealable sentence. So it should be the norm to anticipate an appeal, not the exception. Further then, the court will highlight that in State v. Mackenzie, 2003, 2 SACR 619, Supreme Court of Appeal, the decision stated that where the appeal, it's not relevant because the defense was not vague in the grounds that they raised. It didn't merely state a general error on the side of the court or the presiding officer. It made specific points. And the requirement according to that case is that the appellant must do so and state the grounds clearly and specifically, and that has been done. As to what then constitutes reasonable prospects of success, Plaskett A.J. in State v. Smith 2012, 1 SACR 576, Supreme Court of Appeal decision, describes it concisively as follows. What the test of reasonable prospects of success postulates is a dispassionate decision based on the facts and the law. That a court of appeal could reasonably arrive at a conclusion different to that of the trial court. In order to succeed, therefore, the appellant must convince the court on proper grounds that he has prospects of success on appeal and that those prospects are not remote but have a realistic chance of succeeding. More is required to be established that there is a mere possibility of success. There must be a sound, reasonable basis for the conclusion that there are prospects of success on appeal.
I'm just catching up with my WhatsApps, by the way.
Noted by this court, and I want to place it clearly on record, that in a criminal case, a magistrate or the trial court should not take the easy way out and leave everything to state counsel or the appeal court when it is the correctness or otherwise of her or his decision that is at stake. When confronted with appeal, the trial magistrate is duty-bound to make an honest reassessment of his or her decision in light of the appeal. It is helpful to everyone concerned to know whether or not the trial magistrate still abides by his or her decision despite the appeal. If for some reason the trial magistrate has had a change of heart, it is more honorable to say so than to adhere to an indefensible decision. In doing so, it may save precious time and costs to all parties concerned, and the ends of justice cannot be served by prevaricating and being non-committal when the liberty of a citizen is at stake. Therefore, the test is straightforward, namely, whether there are reasonable prospects of success in the envisaged appeal against the conviction, rather than whether or not the appeal ought to succeed. That is, let me stop there.
Yeah. Tannie judge het al klaar genoeg
That is the
vandag.
general principle applied by courts with regards to an appeal. going to do it in the following fashion so that it's not repetitive and state as follows. I'm going to deal with conviction and sentence in one ruling. Therefore, a court will have to be careful in its judgment in a leave to appeal application not to influence the outcome of an appeal, and for this reason is curtailed in dealing with the merits to the limited extent necessary to explain its reasoning for granting or not granting leave to appeal. So for this reason, the court will refrain from any further comments as to ensure that there is no interference with any proceedings that may follow.
Okay, what does that mean? Why do we have two angles of Tani judge?
With regards to the clear direction from case law, this court is to state clearly that whether it stands by its decision to convict the applicant for the reasons already mentioned during the judgment, and to state so clearly, in this regard, Mr. Malema, the following ruling is made with regards to the application. With regards to the decision with regards to conviction, this court abides by its decision as stated on record. This court has not had a change of heart and clearly stands firm on its decision to convict. Therefore, leave to appeal in respect of conviction is not granted.
Yes!
I've not finished, please.
Yes!
However,
yes!
With regards to sentence,
Papa wag vir jou.
After listening carefully to the address placed on record, in respect of sentence, there is always a possibility that another court may come to a different conclusion regarding sentence. Therefore, this court does not have any intention to stand in the way of such a possibility. Safe to say, no, I'm not going to add that. The court will not stand in the way, and therefore leave to appeal sentence in this matter is granted.
Okay. So I'm confused.
Outstanding matter, that's the issue of the release of the accused. And the accused has been on bail since the 27th of November 2019. So it's 7.5 years ago. He was on warning, I beg your pardon. The accused was on warning. He's abided by every request to be at court, every order of the court. Based on the Hudson, Anderson, and the United decisions, we'd ask for reinstatement of his release on warning, Your Worship. I understand it's not opposed by my learned friend, but I'll allow him to confirm that. Thank you, Your Worship.
Sorry, the question. Are you saying you are applying that he be continued to remain on warning? Thank you, Advocate Oris. Advocate Sisa?
Can somebody explain that to me? Because she just said that they won't come to something else.
Even that the accused can be released on bail. I hear differently now, but I also have no objection if he is released on warning on this regard. Thank you. We had an agreement.
Okay. I mean,
I'm not
we can't win it all.
be difficult. I also, in principle, do not have any objection to the request. Normally, when we go to the aspect of bail pending appeal, there are normal conditions that is applicable, which the applicant will have to comply with. So I'm also in chartered territory now when the status remains on warning as to how we'll deal with the conditions.
I think the normal case will be remains on warning until the appeal is prosecuted. If fails to prosecute it, if it's an adverse finding.
Oh, sorry. He cannot appeal this. He cannot. No. Wait.
7 days.
7 days, yes. Just for my own, sorry.
He can't appeal the conviction, but he can appeal the sentence according to this judge. Okay, so that is what she said. But that's brilliant. So the clapping and happiness still relevant.
Register with the progress. So is there a date which we may agree on, which there can be an email or an update as to the progress? Merely to know it's filed, and that is the end of my involvement.
The appeal against sentence will proceed, but we'll still be petitioning as we're entitled to. for leave to appeal against the conviction, which is within, I believe it's 15 days, which is 3 weeks. Because
Yes,
it's normal.
I think on my side I will have to prepare, or we will have to prepare quite a lot of documents for you for that procedure. It's why I'm asking, more or less, because it's a time-consuming exercise, so that I can, we'll start getting it ready in any event, I think.
My friend's correcting me, it's 21 days. No, it's 3 weeks. It's 15 court days, that's correct.
Okay.
So if we could set the date within 3 weeks of now, Your Worship, because then the Worship can have proof that the petition will have been served and filed by then. It should be an indication of everything taking place.
No.
As Worship. Thank you, Worship.
Thank you. Then, as you've heard, Mr. Malema, the court has no intention of changing the status of yourself, and therefore you remain on warning pending the outcome of appeal and petition regarding conviction. Thank you.
As the court pleases, Your Worship, I think that concludes our round.
Thank you. Bye-bye.
So arrogant. Well done to Tani Judge. Can we all just get a round of applause for Tani Judge, please? I'll explain what this means because Conscious Caracal helped me a little bit over there. Maybe what I can do is just do this quickly. Are you available to come on quick to talk about this? I'm just asking an advocate if he's willing to... Okay, wait. Appeal teen skuldig bevinding misluk, maar appeal teen vonnis slaag. Okay, so thank you for that. I'm not going to mention your name here, but thank you for that. I'm reading some of the WhatsApps here, just so that I can also get a bearing. I'm just getting a bearing over here. Let me just check. By the way, he will be addressing the people outside, and I would love to listen to what he's got to say. So let me know what you guys want to do. Should we continue live stream to hear Malema's thoughts? Let me know with the poll. Let me know what you guys have to say and what you're thinking in this regard. By the way, we hit 219,000 subscribers. Thank you very, very much, everybody that participated in that. We have hit 219,000 subscribers. Absolutely amazing. Absolutely amazing. Thank you. Thank you very much. Thank you. Let me just check if I missed a couple of... we'll wait. I'll just check what... Okay, so 92% of you are saying wait. Because you want to hear what is being said here. I don't want to listen to what the SABC has to say with regards to this. Well, I'll just run this in the background. Wesley, thanks for the £2 saying Malema deserves his sentence and much more. Zero, thank you for that. Zero Fox gave a 35 Rand super chat saying, can't wait to hear what Carl Nyhorse has to say about this. Tsak your knee. And then thank you for that, Zero. And yeah, he's probably going to have a lot to say. He's probably also having a meltdown right now. Diggy Doug, thanks for the 35 Rand saying, Ronaldo, you played that song while I was in the airport. I've never got so many side eyes in my life. Did I turn the volume down though? No, I didn't. Lekker. I love that. I love that, Diggity Dog. Yeah, let everybody know. Bloemfontein, VetLab, thanks for the £5 super chat. I appreciate that. And then Bronx, thanks for the 100 Rand super chat, saying a higher court may decide on a more severe sentence. Well, that's the thing. Let's do this quick. So let me just check if there was a response here or not. I'm waiting for a response. So let me just minimize this so I can see if there's a response. But as soon as he starts talking, then I will redirect. But yeah, so he got a 5-year sentence on charge number 1. Charge number 2 was 2 years and then 20,000 Rand for the rest, right? So it is not 7 years, it's 5 years because it runs concurrently, right? Now, the judges said that he can't appeal his conviction, meaning he was found guilty, but he can appeal his sentence, which is 5 years. But now, the fact that she granted leave to appeal with the sentence doesn't change the fact that higher courts can still decide we don't want to hear it. So the High Court, which is now the next court, can go, we don't see any great prospects of success, but I don't have to actually explain it because we've got Mark Oppenheimer that is willing to come up here to speak to us about that. So let me just do this quick. And then let's hear what he has to say with regards to that. So let me just post this over here. People in the chat, just let me know when you see Julius Malema addressing the crowd so that I can ask Mark if we can just cut it short so that we can look at that. So I need your eyes and ears here to help me because I only have so many screens that I can work from. So that'll be appreciated. If you can just let me know when you see Julius Malema on stage addressing the crowd, it'll be appreciated. Let me just do this quick. Just give me a second. Just answering to some people, yeah. Max the Mage, thanks for the 14 Rand saying Chuki to met die bliksem. And then Leslie Grunewald, welcome to the Voortsackers and welcome to everybody that signed up to become a Voortsacker. While we wait for Mark Oppenheimer, this is the benefit of becoming a member to this channel. No. Well, how's everybody? So just a quick break to ask you to please consider becoming a member to this channel. If you become a member, you become part of the family, the Voortsacker family, as you can see. And the perks of being a member to this channel is that you get access to videos before the public. If I record it the night before, you get access to a members only WhatsApp group and you get access to one stream a week that's only for members where I take questions from members, we have a chit chat and just have a good time. So if you enjoy the content, if you like the channel and you support me, then please consider becoming a member. You can do so by clicking the join button below and it'll cost you 39.99 Rand a month. All right, thank you. Back to the normal programming. I almost did a stripper chat there, but when I went to the wrong one. So sorry for that. All right, we're just waiting for Mark Oppenheimer to join to give his opinion on this. Did I miss some gifted memberships? Who gifted a membership? Master, thanks for the 14 Rand saying this bullshit. Hy moes met kafs uitgeloop het. We can't get everything, you know. We can't get everything. All right. So, oh, I did see that somebody gifted memberships, but who was it? It was Tony, and it doesn't show me the other person. So please just tell me because I can't see it on my side over here. Who gifted memberships? Please let me know. Michael Maritz gave a 200 Rand super chat saying, thanks to AfriForum for the outstanding work. Many more cases to pursue. Thank you, Ronaldo, for a great show. Well, thank you. It's my absolute pleasure. And thank you for the support. Thank you for the 200 Rand. And yes, indeed, well done to AfriForum. If it wasn't for them, this wouldn't have happened. So the bigger AfriForum gets, the more they can do things like this. And I would implore you to go and sign up and join AfriForum. Vanessa Blossom, thanks for renewing your membership. It is greatly appreciated. Thank you. Thank you very, very much. Really appreciate it. And Conscious Caracal just posted the link there. Just spam it, Conscious Caracal. Oh, is he out on stage now? Okay. Let me just check here. Maybe what I'll do is I'll get Mark on after that. I will check. I don't see him being on the stage yet. But maybe what we can do is, let me just check here. I need to take this out and charge it for a couple of minutes because this is flat. Can you believe it? Absolutely flat. Future looks bright gave a €5 saying, can he still be a member of parliament and on the judicial council while waiting for his appeal? Yes. Yes. That's the weird part. That is the really weird part out of all of this, is considering he is a convicted criminal, he can still choose the judges. But that's South Africa. Oranje man, thanks for the 14 Rand saying, Viva AfriForum, volgende is Mbalula. Yes, please. Yes, please. Let's do it. If he does appeal, they can always overrule it and give him a harsher sentence. So that is the risk that he's running, and that is what I said many times. So is he on stage? Is he ready? Is he speaking? Or what's going on here? Just tell me who gave the memberships besides Tony Nagy. I already said thank you to Tony Nagy for the memberships. Did I miss it? Who gifted the memberships? I can't not thank the people. I have to thank them. Oh, Joe van Wyk. Thank you, Joe. Aitza, Joe from Truth Report, gifted 5 Ronaldo Ghost memberships. Thank you very much, Joe. Lots of love. Appreciate you. Wonderful, amazing human being that works for Truth Report. Sy's 'n regte mens, se mens. Awesome human being. Always got a smile on her face, cracking a joke. Thank you, Joe. Appreciate you. Let's just listen to what's going on over here. Over here. Let's see if they already...
Visuals there. A sea of red, if you will. A number of supporters there waiting to be addressed by EFF leader Julius Malema. My colleagues in transit now to try and get us the exact perfect visuals of EFF leader on the stage now, as has become the norm, to address those supporters gathered there. And I suppose the most important becomes to almost give them a message of support, that even as they are there as supporters of their own leader, but the leader needs to somehow give a message.
Yeah, okay. The other thing I wanted to ask, considering there's still like 7,000 of you here, is we know that South Africa is at a crossroads at the moment when it comes to ideologies and parties and who they are trying to get to support them. I think that it's very clear to see that the ANC has doubled down on their ideology of wanting to align with Russia, China, and even Iran. We know that MK and the EFF are exactly the same. And if you listen to what the DA has to say, they want to appeal to more black support. And we know that 67% of the population vote along communist or socialist lines. And Jordan Lewis has come out and said that, you know, we want to appeal to more voters. And if you look at how many EFF and ANC former members and councillors and members of parliament have joined the DA, you can see that there is going to be a fundamental shift in the DA moving even more leftist, like the Democrats are doing in the United States. So if you want to counter that and you don't want to support woke leftism or communist and socialist policies, then I highly recommend that you consider the Freedom Front Plus. And I've pinned the post over there where you can sign up to become a member of the Plus. Now listen, the Freedom Front Plus is not only for Afrikaners. The Freedom Front Plus is not only for white people. The Freedom Front Plus is for people that love this country, that believe in a God, that believes that we should go and return to our Christian values, because 85% of this country believe in Christ. And if you like your freedoms and you would like for minority rights to be protected in this country, if you look at what MK is doing right now, trying to remove Section 235 and also Section 25 of the Constitution, those are expropriation without compensation and self-determination. Now more than ever, we need a strong conservative party to fight for minority rights. And guess what? Minority rights isn't just white people. It's not just colored people. It's not just Indian people. It is also black cultures that make up a minority that's not Zulu or Xhosa. So I highly recommend that you consider using the conservative values that you have and getting behind a political party that will fight this woke leftist, communist and socialist narratives. So click on the link, become a member of the Freedom Front Plus, and form part of the change. Because with your support, we can go from a smaller party to a really big player in South Africa. And then we can implement communist. We can fight against communism and implement conservative values. So anyway, I mean, how many times is he now going to say viva, viva, viva? Let's listen.
Come forward, comrades. Into esizeleyo apha nguCommander-in-Chief nguluzayo. Let's leave everything else you're doing there at the back and focus here. The Commander-in-Chief and President is coming to address us. Masondeleni sonke fighters. DJ, President Rekangene endini elizwi yapha. Help us out.
Don't we have a better song? Don't we have I think we've got a better song here. I mean, let's just make him come out for the better song. Wait, what's going on here? I'm completely lost at the moment with what's going on. You see, this is what happens when you got a million things running at the same time. So I just want to check quickly where the hell did the Zoom link go to? Oh wait, here it is. Here it is. Just wanna quickly get to this. How's it, Mark? How are you doing?
Good.
Thank you for joining us quickly, because I see that Malema is about to address, so we can quickly just ask a couple of questions. What is, so we know the verdict, we know the 5 years and 2 years, but it's 5 years concurrently. All I want to get from you quickly, and I'm sorry, and everybody, please be sure to go and subscribe to Mark Oppenheimer. You can follow him on social media. I'll post a link in the chat. Also, he's called Brain in a Vat that is phenomenal. Just tell us briefly of that. It's like that you can't appeal the sentence, but you can appeal. You can appeal. Mean that
yes. So the process that we said, I would like to appeal to another court.
Mm-hmm.
And there are two kinds of the merits. So it's the fact that he was convicted, and the second is on sentence. And so she has said, I'm not going to grant you the right to appeal on the merits, but I will on sentence, because she thinks there's reasonable prospects that another court might come to a different conclusion. But that doesn't mean that it closes the question on the merits, because it's available to Mr. Malema to petition the higher court and say, for XYZ reasons, we think that you should grant us an appeal on the merits question itself.
So you can, so pretty much she's just denied it on this level, but they can still do both in higher courts, if I'm
They
understanding
could.
it
So
correct.
they have the ability to decide whether to grant it or not, and it's possible that a court says we don't think there are any reasonable prospects of success on the merits question, go all the way up to the Constitutional Court. And at every juncture, there'd be a question as to whether the merits portion should be heard on appeal or not. And then the separate question about the sentence would be heard because their leave has been granted.
So what is the difference, if I can just understand, between, like, so did it make it more difficult when she said, I'm not granting you leave on the conviction? Like, can you explain it like I am an idiot, because I am an idiot in this regard? Like, so why did they have to go through the process if they can just anyway go to a high court and ask these things and they can still go and do it?
Well, it does make it harder. So once a lower court has denied you leave, the petition process, sort of has a certain stringency to it. In the case that courts do entertain appeals, even if our courts refuse leave. So, for example, in the old flag case, which I'd argued, there the High Court had refused leave, and so AfriForum had petitioned, and the Supreme Court of Appeal had granted leave, and so the case was argued. It doesn't close the door, but it does create an additional hurdle. And it demonstrates a confidence that she has in her original decision. And she talked about that when making the decision, saying that, under circumstances where a magistrate thinks that they've made the wrong decision, they shouldn't be shy about that. They should make it explicit. And she says, I didn't get it wrong.
And what is your take on the sentencing, if you're allowed to, tell us? Are you happy with the outcome? And what do you think the odds of success are, both for the conviction and the appeal in the higher courts?
Well, the general principle around sentence is referred to as the triad of Zinn. So there are three factors that you take into account. So the first is the nature of the offense, the nature of the offender, and then the interests of society. And so when she delivered her judgment on sentence, you hear her referencing all three of these factors. So the one is, she says, equality before the law is a pivotal principle. Everyone is entitled to a fair trial. But she does say that given that Mr. Malema holds public office, that there's reason to then have heightened scrutiny, which is what you find, at least in principle, in our hate speech law, which is that the status of the speaker matters. And there's a decision from the Constitutional Court saying that, those who have high office must be given, heightened scrutiny. And then she says, the interests of society are very important. We've got a scourge of violence, that you have drive-by shootings in East London, and they're not referred to as celebratory shootings. And so endangering the lives of others is a serious offense. So she takes all of that into account. She also looks at, one of the examples she looks at is, in terms of case law, is someone who was convicted and given a custodial sentence. And the defense had argued that that should be disregarded because the person had been incarcerated before. And she pointed out, well, when the court handed down that sentence, they acted as if it was a first offense. And so there was no differentiation. So it does appear to be in line with the case law.
All right.
And obviously had the power to grant a 15-year sentence. So there's a sense in which the 5 is lenient.
And it's lenient, but if he does take this, and if a court hears this, then there is an opportunity that they can impose even a harsher sentence than what she gave.
That is a possibility. So if the prosecution cross appeals and says, well, we think that 5 years is too little in the circumstances, and it should be greater, that is a possibility. So there is a risk. So, for example, in Oscar Pistorius' case, there the state thought that both the merits and the sentence were too low, and so they pushed for a murder conviction and a higher sentence, and they were successful on both.
And then, can you give comment on whether you think this will be sexfully? Whether you think it will be successfully appealed, or can't you give comment on that?
I can't. There's a bar rule that prohibits me on prognosticating about future outcomes. So all I can do is sort of give you a lay of the land about how the law operates.
Are you allowed to tell us what your thoughts are on how the judge handled this case?
Yes. So my sense is that she acted exactly like you want a judicial officer to act. And she was quite clear in delivering her sentence that the role of the judiciary is to be independent and free from bias and, act without fear or favor. You have a situation where you've got a large crowd of people that had been assembled outside the court. She made mention of the fact that this sort of made it difficult for the court to operate because you had these large crowds of people. And she says that the role of a judge is very different from that of a politician. My sense is that she coldly and mechanically applied the law, wasn't intimidated one way or the other, made quite clear that she said, I'm going to treat you like every other citizen, and I'm going to take into account that you have this public office, which pushes further heightened responsibilities, that you could be sending a signal to others to duplicate your behavior. But my sense is that she's acted in a fair manner and under conditions of abuse. So, there have been lots of people calling her a racist and, moves to try and undermine the proceedings. And, she has diligently proceeded throughout.
Awesome. All right. I hear that Malema is on stage. Where can people follow you, by the way, and how can they get in touch with you?
Yeah, so there's a Mark Oppenheimer channel where you can see, many of the interviews that I've done. The footage from the original Kill the Boer case is there as well. And then there's my philosophy channel, which is Brain Debat.
Okay, and I definitely would like to get you on for a full unpacking of this whenever you have time. But thank you for coming on in short notice and for helping me with my limited brain capacity on what happened there. But thank you, Mark, and good luck. And everybody, please go and support the channel, and also specifically Brain in a Vat, which is phenomenal. Thank you, Mark. Appreciate you. Have a lovely rest of your day.
Absolutely.
Cheers. And next up, just hold on. Next up, I can confirm that, yes, we have somebody that is on stage right now. Sorry, we're just quickly crossing over. Here we go. There we go, yes. And now? Oh, wait.
Thank you very much, fighters. Let me first greet our president, Julius Malema.
Convicted criminal.
Amanda.
So where to?
Amanda.
So where to?
Before I bring the president, I want to bring the leader of Mashabi to come and bring the president a poem.
Aya malimba ke tsebe bokhalaka. O ya khatangwe ya penama. Ene wa chetsi ba chabana bangonga. Ba nya chitulula chifanjerere. Ba chilamba kufa. Ene mushabi asashe mbutulu kwembe ono shaba ngombe. Ndiyene muzungu nukufasena. Shalom alaikum.
Amanda. Amanda.
Sema vir jou.
Amanda. As Jacqueline daar.
Môre gaan jy tronk toe, boeta.
Ja, dis dan nie eens aan my shop.
Klein man wat groot wil speel. And a little man want to play big games. Klein man Malema. Little man Malema. Bedoel bedorven brat met rooibaret. Yes, you with the red beret. Lieve uitspraak elke dag. Hate speech every day. Allemaal wat niet saamstem nie. Anybody who disagree, you chase away. Jy skree en skel, you shout and scream. Call names, want allemaal moet luister. Maar niemand van jou nie, ja, nobody likes you. Jy so alleen, sad little man. Hey, jy love your mic, love your drama. Love to spread the fire. Hate everybody who don't clap when you say revolution high of it. Swart in die color. As hulle nie klap nie, then they're the enemy.
Okay, I can't even see you guys at the moment, so I hope that you're still
we are
there.
Here, we are so very happy, but though we wanted to observe the law or the law of the country as well, that is still consistent.
Sorry,
we know that when we look this from our own perspective, we see that it has got many influence from different institutions or from different political parties. So we know that as a leader of a political party, there is a bearing for him to be put in jail. So as we are from the Labour community, as resident people, we know that the journey is still continuing and will win at the end of this road. Viva!
Yeah, okay, buddy. Good luck.
Shalom, Mapaita, shalom. Shalom, Mapaita, shalom. Shalom, Mapaita, shalom. Irini kisikaga bakamata. Marali anziba kamu. Yate anzibi abuji dalba alim bele juju.
Oh well.
Yalo banabae so akina jenga dia bauje dinchi. Dia baurengeli dia lele juju rumogai. Albona juju. Ate jona lemboje kidomudia katruba.
Yeah, okay, I mean, good luck, buddy.
Manda!
Soweto!
Manda!
Soweto!
Viva EFF, viva!
Check!
Viva EFF, viva!
Check!
Long live the Commander-in-Chief, long live!
No!
Long live the Commander-in-Chief, long live!
No!
Long live the Commander-in-Chief, long live!
No! What?
Amanda! Amanda! I saw me fight, I saw me! 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 Amanda!
Whip!
Thank you very much, fighters. Swera ngo 2018. Silana mhlanje. I'm going to not even waste time to bring the commander-in-chief. Gobalenda was Kale Sisa Dukashe Stadium to say, President, we are here today and we are still moving forward. Portugal's President and Commander-in-Chief Uslinga Zumkombandela. Amanda! Amanda!
Re.
Amanda!
Re.
FIFA, EFF, FIFA!
Re.
Tata, EFF, Tata!
Re.
Tata, EFF,
Down with AfriForum, Tata!
Down, AfriForum, down! Down, AfriForum, down! Down, racism, down! Down racism, down!
Down freedom, down!
General,
down freedom!
Our leaders, the National Chair, DSG, TG, and Deputy President.
PDFs.
Our parents who are here, our pastors, traditional leaders, the leadership of the Youth Command, our family members who are here. We support the fact that today was not an easy day, but at the end of the day, the fighters emerged victorious because ground forces have always stood firm behind the logo of the EFF. We want to salute you, the ground forces, for always being there from since 2018 until to date. They thought you were going to be tired, only to appointment the future.
Okay. Tembeko says, Asoweto, your Xhosa has been improving bit by bit. I was making a joke. I know it, Asoweto. But I know a bunch of Xhosa. The EFF keeps on saying, soon. Alamasimba. What does that mean? Soon, Alamasimba. Onkwako.
She invited us to the court.
I didn't call you that, by the way. I'm just saying what the EFF keeps on telling me. I know what it means.
If you don't the forces have always stood firm behind the logo of the EFF. We want to salute you, the ground forces, for always being there from since 2018 until to date. They thought that you have an appointment with the future.
Okay. Tembeko says, Asoweto, your CASA has been improving bit by bit. I was making a joke. I know it, Asoweto. But I know a bunch of CASA. The EFF keeps on saying, soon, di Masimba. What does that mean? Soon, di Masimba. Onkwako.
She invited us to the court.
I didn't call you that, by the way. I'm just saying what the EFF keeps on telling me. I know what it means.
If you don't come to court, you get arrested. If you come to court, they say you are disturbing court. Therefore, you must go to prison for disturbing court.
Whatever.
So we don't know what to do anymore.
Stop firing guns.
That was not the law. That was racism speaking. Magistrate Oliver is a racist of note, and she must know that in her sleep.
Okay.
That she's a racist and she's possibly a member of AfriForum. That's why when you mention AfriForum, she cannot hide her emotions. Yesterday, when SC Mugai Toby mentioned AfriForum, she jumped. But it was not Mugai Toby who was mentioning AfriForum. It was the state which wrote in its heads of argument.
No accountability whatsoever.
What the state wrote, she said, don't bring AfriForum. And Mugai Toby said, I'm not bringing AfriForum. The state wrote AfriForum.
Yesterday, he didn't call her a racist once, and now that he's like being sentenced now, racist. Figure.
Got those heads of arguments 2 months ago. She was not aware that by saying she wants to read inside court, she was confirming that she did not read the heads of arguments. She just entered court without knowing what is contained in the heads, in the arguments that the lawyers were putting before the courts.
Whatever.
So we are tried
Convicted
by
criminal.
a magistrate who doesn't read.
Convicted
who
criminal.
read when you appear in front of her.
Convicted
Otherwise, when you are not there, she doesn't read the heads of arguments.
Yeah, okay.
If you read heads of arguments and someone says AfriForum, you'll
1,000 Rand bet that they're going to sing Kill the Boer, Kill the Farmer. Anybody want to take that bet? 1,000 Rand bet that they're going to sing Kill the Boer, Kill the Farmer at the end of this.
What are you talking about? We're trialed by a magistrate who doesn't read, who uses emotions, who speaks politics, who says we are stopping people who are coming to collect maintenance. We're stopping grannies who want to come to court.
You did.
But in reality,
You did.
this court was never closed. The public continued to use this court. So she doesn't have any reason, none whatsoever.
That's not why you
She
got the
goes
sentence. You're
around
focusing on the small things.
fundraising reasons why
The small
we
Inyana
must go to
skeletons.
prison. They took a firearm which they say I used. She was not aware when it was mentioned in court that the firearm has been handed over back to the owner. She appeared shocked, but the witness testifying for me wrote about the firearm being taken away. She was not aware. You know why? She doesn't read. She doesn't know what is contained in the documents that are before her. So we are dealing with someone who doesn't apply the law.
Oh.
The law, whether you hate someone or not, you have to answer the question.
She doesn't
what
hate
does
you.
the law say on this matter? She will.
Cheryl, thanks for becoming a member. Greatly appreciate that, Cheryl. Thank you.
Heads of arguments, 21 pages. And those 21 pages are quoting the judgments which were written before about matters that are similar to this one. How can she read all of those judgments if she can't read 21 pages?
She did yesterday, in case you forgot. Simon Elliott, thanks for becoming a member. And Carlo Hendricks, thanks for the 14 Rand saying, brr, bah, convict in charge. Yes, there we go.
Friends, they are not the same WhatsApp group. She's the most incompetent magistrate who read a judgment for 3 days. It is never done. She does so because we suspect she doesn't write her own judgments.
No.
They ask a simple thing.
She did that because she wants to make sure that the case is airtight and you can't get it on appeal, you idiot.
And they do not say anything. You still ask for 30 minutes to grant a leave to appeal. So because we suspect she doesn't write her own judgments.
No.
They ask a simple thing.
She did that because she wants to make sure that the case is airtight and you can't get it on appeal, you idiot.
And they do not say anything. You still ask for 30 minutes to grant a leave to appeal or not. You are not asking for 30 minutes. You are still going to ask your masters, do I grant the leave to appeal or not? So you are dealing with an invisible hand that is controlling the proceedings in that particular court. So we must make sure that she gets reported to the Magistracy Council Commission because the prosecutor knew about the judgment before
now you're so
she could
clever.
read.
Now
the
you're
judgment.
clever.
A day before,
now you're clever.
She told accused number 2, you must go and fetch your gun tomorrow. And the accused number 2 said, you can only fetch a gun if you are not found guilty. How did the prosecutor know that accused number 2 is not going to be found guilty to an extent that he tells him to go and fetch a firearm? That's the first misconduct the prosecutor committed. The second one, which the Eastern Cape, East London sub-region must go and open a case of perjury. He lies in court yesterday. To lie to court is a criminal offense. He says, we gave the gun to accused number 2 after he was acquitted. When you said not guilty, that's when we gave accused number 2 the gun. But he forgets that when you collect and a weapon or item that was used as evidence, when you collect it back, you must sign for it. There must be a date, there must be a time. So if it's 10 o'clock, they will write 10 o'clock, they will write a date. You look at the time of collection and then look at the time of judgment that he collected before the judgment was passed. That is the second misconduct of a prosecutor. But a prosecutor has got no duty to hand over the item which was used in court without a judgment of a judge. He gave himself a power he doesn't have. He took the evidence before the court and handed it over to accused number 2 without a judge saying, you can now return this item back to the owner, or you must give it to the state to destroy it. So he thought he's got the power he doesn't have. The only thing we need to do is to make sure that this prosecutor, who is arrogant and suffers from a short man syndrome, is taught a lesson. And we can only teach him a lesson by sitting on his neck and making sure that he's prosecuted and is arrested for lying to court and is disciplined at work for exercising the powers he doesn't have. And this magistrate must be reported to the commission. Why? How did the prosecutor know about the judgment? Because you are the only one who knows the judgment. Only you, the magistrate, could have told the prosecutor about the judgment. And to tell the prosecutor about the judgment outside the representatives of the accused, it's wrong. It's not allowed in law. If there is anything you want to communicate to the prosecutor, you must call the defense to come and you communicate in front of a defense. So clearly, you've got a special relationship with a prosecutor as a magistrate, and that is a misconduct on its own. So we must make sure that we pursue her for being ill-disciplined and abusing her power as a magistrate. So we are going to appeal this matter. We are going to make sure we go to Grahamstown and we are going to dismiss a judgment which was poorly read and which was poorly written. She has granted us leave for appeal on sentencing and refused to give us leave to appeal on conviction. We must petition the High Court to appeal the guilt verdict and the sentencing itself. Today, because all they wanted was to have me sleep here for one night, but they didn't know the reason why the Deputy President is not here. He is at Grahamstown. Because when you apply for leave to appeal and they refuse it, you have to apply for bail. She has a right to refuse it. Then you must petition the High Court to apply for bail at the High Court.
Okay.
So we've got the Deputy President in Grahamstown with papers ready so that when she says, you are not getting bail, you are going to sleep here, the Deputy President immediately files the papers at the High Court and make an agent application. We are not small children. We prepare for any eventuality.
But it was wasted because she granted you leave to appeal for bail, did she not? So wasted EFF resources, did you not?
That we are dealing with an invisible hand, and therefore you have to be prepared at all material times.
Yeah.
The judge at Grahamstown was ready and waiting to listen to our case at 3 o'clock because we had already told the clerk of the court that we are coming. Not only that, we had a chopper waiting at the airport for the legal team to fly immediately.
Where do you get all this money? Yo, tell us more. Reveal more, please.
And we must fight with everything. 2 minutes they must see you here, 2 minutes they must see you on the other side. That is the power of the EFF. We prepare from all the fronts because we are fighting the enemy, and the enemy is white supremacists.
Oh, here we go.
So now, no sober judge will ever agree that a person shoot 1 bullet and then is sentenced for 5 years. It is
1 bullet. Was it 1 bullet?
Judgment.
Why are you lying? Wasn't 1 bullet?
Reasonable.
I believe it was 22, wasn't it?
Presiding officer will never come to that determination. So, comrades, we are done with her. That's why when she said to me, you can leave now on a free bail, I looked at her and I said, bye-bye. Because I've seen her ugly face for too long.
Wow. Hey? Wow.
Before that ugly white face, I'm going to the highest court where they don't use emotions. They use the law. What does the law say? And apply the law. So we must not even look back. We're going forward. The campaigns of the EFF must continue business as usual. I told you when she found me guilty that I'm going to appeal until the highest court.
Good luck with that.
Until the constitutional court. So those who thought they will have me in jail, you must know I'm still around.
Can somebody post a link to that song, please? People are asking in the chat.
I told you yesterday that tomorrow I'm going home with you. And that's what is happening. Wherever the enemy is, it's highly pained by the fact that we are going home. We did not even have to pay for a bail. They just said, free bail, go home. So we are going home to work for the EFF.
Whatever.
That's what home means. It means the work of the EFF continues.
The
we are
EFF
going
is
to
dead.
do our door-to-door. We are going to register those who are not registered. We are going to make sure that we win municipalities when the elections come.
Thanks, Mel,
They
for
are
posting
trying
it.
by all means to silence this voice. They will never win. Once more, they failed today, they will fail tomorrow, and they will fail in the near future. The sooner they accept defeat, the better. They will never win against us. They tried us when we're still young, and they will never win with us when we're this old. We've got an experience of a 65-year-old at a 45-year-old. So these Lambas gave me a title called Ishe. That title is only given to people who are 65 years old and above. But I was given that title before I even turned 45. They said, when they were arguing with the president of the Lamba Cultural Association, that you can't give a child a title reserved for the elders. The president of the Lamba Cultural Association said to them, tell me one thing that he has done, that you have done, which he has not done. We are giving you this title because you are 65. Tell us, is there anything that you did in your life which Julius did not do in his life? They couldn't answer that. But he turned around and said, if we were to ask Julius, have you ever done something that this old man of 65 years he hasn't done? The question.
We have this random user in the chat saying Black Americans for Malema. Okay. If you want to really associate yourselves with this, then okay. Good luck with that.
Dead. Still, he emerged and continued with life. When they put a concrete on his grave and thought this plant will never rise because we have put a concrete on this plant, he emerged through concrete, and he's still standing till today. That's what they don't want to see. When they expelled us from the ANC, Baleka Mbete saw us in parliament. And then she was shocked because she was confusing parliament with ANC meeting. She was like, what are they doing here? Because we expelled them. That's when we had to remind her, or we are not here because you invited us. We are here because our people brought us here, whether you like it or not. So they've been trying to...
He's got a lot to say, but I mean, ultimately, like, my friend, you're a convicted criminal and you've got a 5-year jail sentence. Good luck. You can try and claim whatever victory you want to claim. Seriously.
I've got triple what they took from me. So I don't know why they're not getting tired. And they thought, no, let's leave him. He's going to die. He's overweight. I've lost weight.
Yeah, slow puncture.
Of gout or anything of that sort. They are trying all manner of things. And still I rise. Because they never gave birth to me. And no man or a woman who didn't give birth to me can determine my destiny.
No man or woman who gave birth to me. Yeah, I mean...
You fight with me, my ancestors will emerge. They have never failed me. That's why if...
They failed you today, buddy. Oranje man, thanks for the 14 rand saying, remember, judges and magistrates consult each other. Yes, that's true.
But this one of ours, we are going back home with him. And we want to make sure that he returns home safe. So if you've gotten access to them, just tell them, please leave him alone, because he's still going to emerge. When you finish him this side, he comes from the other side. I mean, you were demoralized.
Carlo Hendricks, thanks for the 14 rand saying, shouldn't he keep this for prison story time?
2,
Great
3,
one.
4 people
Love
left.
it. Thanks for the super chat.
700,000 joined the EFF after 3, 4 people left. They thought that those people formed the EFF. And those people say they formed the EFF because it was formed by you. Why didn't the EFF live with you if you formed it? Why is the EFF still alive after you left if you formed it? They did not form the EFF. The EFF was formed by the blood of the workers of Marikana. The EFF...
okay, whatever. Heinrich Schoenfeld, thanks for the 140 rand super chat. Appreciate it, buddy. Saying Malema playing the race card and insulting the judicial system might not work in his favor when he goes to the High Court. Don't interrupt your enemy when they are making a mistake. Thanks for the super chat, Heinrich. Appreciate it.
EFF was formed by the poorest masses of our people. It doesn't belong to us. It belongs to the future generation of African children, because this is the only weapon they have to fight racism, to fight poverty, to fight unemployment, to fight inequality. So no one, no individual must ever claim they formed the EFF. You want to know who formed the EFF? Just go and look at that mountain. in Marikana.
Eugene, who gave a membership chat for 10 months, says, can this speech be used against him in the appeals court?
Does not come from a
Any
village
expert
called
here that can tell
Mahonisi.
us? I'm sure it
comes
must.
from
I'm sure it must.
Marikana. That's where we owe our existence to the people of Marikana. We owe our existence to the widows of Marikana. We owe our existence to the children of those who were killed in Marikana. And for as long as the workers are still receiving lower wages and they are still fighting for their rights, the EFF will still exist, whether I like it or not. The EFF is spoiled of choice. You must go and look at the parliamentarians of the EFF.
I don't believe it's perjury, because perjury can only happen if you're under oath in court. He's not under oath in court right now. He's just giving his opinion.
Only the EFF has got Naledi Chirwa in parliament. The rest of them have got Sisi Dukashe. So once you've got the young on your side, you are guaranteed of the future. We are not a veterans league. We are an organization of young people, very energetic young people, and the future looks bright because we've got Lonzi, who is in parliament fighting for the rights of the people of South Africa. We've got all of you here. Even if you kill Malema, another Malema is already born. That Malema will emerge and take the EFF forward. So we want to say to the police, you are here in your numbers, in your uniform, and you took an oath not to take illegal instruction. But you are here on illegal instruction because you're not supposed to be here. You're supposed to be in the office of Oscar Mabuyan because he stole masters at Fort Hare. That's where you're supposed to be. You're supposed to be on the streets fighting criminals who are raping women out there. But you are here. There was another one inside court, many of them wearing masks. I was like, why are you wearing masks? Are you that ugly you don't want us to see your face?
Oh, you're personal, eh?
They must stop sending police to destabilize the proceedings of the court and blame the EFF. They must blame themselves and the police. Why do you bring a special force of police inside court? Majority in that court is old people. The young people are outside. You bring policemen, highly trained, to go and guard this old man who's walking with a stick. Or this, what can this old man do to that old judge? The only thing he can do is to take this stick and point at that judge. So tall and so taller one day. But you bring a special task force in court when there is a problem of extortion in Umtata, when there is a problem of gangsterism in Gqeberha. You bring police and want to complain about state resources instead of using the resources of the state effectively to crime in the Eastern Cape, where our people are being murdered. Some commanders do not apply their mind. We were in an ad hoc committee. You remember the EFF shutdown. Police spent 8 million to stop an EFF shutdown. EFF shutdown is a peaceful protest. How do you spend 8 million as if you are preparing war against people? War against the people protesting stop load shedding. It was made me
are
on
you on
police to
about?
go and stop.
What's-
Instead taking that meal and go and fix me to